Right.
Item number 804.
We have to give you a longer date, 8th October.
Your Lordship. Councils come from Bombay, so
8th October, you have a definite date.
like
That's fine.
Without a mention. Or if you want an adjournment, wait till the matter reaches.
Actually, if my lords will see in item 39, the office report states that
We may or may not reach up to that item. If we do reach it and you want an adjournment, please make sure that either you're here or someone represents you.
Your Lordship, if I may please mention item 21.
No adjournment mentions, please. Wait till the matter reaches.
Your Lordship. Item number 4.
Item 4, that 4.3 has to be. Along with the counter. Only Amul Raj.
yes, sir. Before that, my lords, may kindly see these short notes. There are 4 appeals in these. Lords, may kindly see. There are totally there are 11 accused persons. One accused was died during the appeal. Then one person became approver. There are then remaining 9 accused persons. Out of it, there is a lordship may kindly see.
Yes.
Page number 1.
Page number 1 of?
Page number 1 of my note.
Note.
Comprehensive note, everything is there.
Very good. Note. You are happy to.
Sorry, I'm so sorry. Total 9 accused, A1, A2, then A5, 6, 7, 9 acquitted by the High Court. Then the remaining the convicted A3, A4, and A8 Out of it, A3 already granted, A4 is granted bail in 2019. I was appearing in that matter. A8, there is under 11%, that is also granted bail in 2019. 22/7/2019. I am also saying the parity so I have undergone
11 person's conviction was confirmed, is it?
3 persons.
3 only.
Only 3 only. Against other 5 people, the state has filed appeal. It is also pending.
That is pending.
Yes, sir. I put the chart. Totally 9 persons. Others are acquitted except 3. Out of 2 other 2 people already. It has been 6 years they have undergone they have granted bail. Now he has already undergone 11 years.
Your sentence was the same, all of you?
Yes, everything is same. Everything is same. A8 as far as that is arms act is there. As far as me is concerned, that is not there. Lords, me kindly see the last page. Third page, I have given the chart of that. What is the sentence? The chart 2 says is A4 and A4 when it was granted. Then the chart 3 sentence undergone Except 302 other sentence I have already undergone.
Who applies for the state? Parity?
My lords, the other co-accused have been granted bail. My lords may decide on the application. The only request is that the
We're
main.
only asking you whether there is parity between this gentleman and the other two who have been granted
My
bail.
lords, I have to get in.
That is the reason why it's coming up. What do you mean I have to get instructions? If you look at the record, you can tell us whether there's parity or not. You've not looked at the record. You've not looked at the file.
No, my lords, my laptop switched off, my lords. That is the reason.
Without the laptop, you're completely
Apologies, my lords.
unable to work, is it?
You do one thing, you take this file, sit at the back, read it, and we'll take up this matter later.
Please.
Don't go anywhere.
We'll take it up immediately after the bail matters are over. What
Please.
item 4 to 12, I think. 4 to 12. So after 12, we'll take up your matter. Be here.
Please give my file 4.3 to 7.
Great.
Item 5.
There's too much unnecessary.
Item 5, because he has filed a counter.
Item 5.
Relying on two antecedents, my lords. Yesterday he has filed a counter. He's relying on two antecedents. My lords, I am having the order.
What is the status of the trial, though? The counter, you've not said anything.
Your Lordships, in the counter I have mentioned.
What have you said about the trial?
Your Lordships, charges have not been framed. It is at the stage of non-bailable warrants ready. So, Your Lordship, some of the co-accused have not been appearing before the trial court. So, it's at the stage.
Why does the High Court say the trial is delayed?
Your Lordships may kindly come to para 8 of the impugned judgment.
Para?
8.
গুরু, দারুণ দোটানার মধ্যে আছি রে। নিজেই নিজেকে প্রশ্ন করে নাজেহাল হচ্ছি। গুরু, তুই ঠিক আছিস তো? রিটায়ারমেন্টে পরে লাল স্পোর্টস কার নেই নাকি ওয়ার্ল্ড ট্যুর?
এক কাজ কর, তুই ইচ্ছে মতো পোলাও বানা, আমি অর্ডার করছি।
পোলাও না, প্ল্যান।
সরি, প্ল্যান?
লাইফ ইন্স্যুরেন্সের রিটায়ারমেন্ট প্ল্যান, গ্যারান্টেড পেনশনের সাথে। এখন তোর গুরুর সব স্বপ্ন হবে পূর্ণ।
গুরু, তোর এই স্পোর্টস কার 2 সিটার না?
এখন পোলাও কে বানাচ্ছে?
এই আওয়াজে কথা বলিস না।
ওকে, সরি।
নর্মাল কথা বল না রে।
দাদা, স্বপ্নদের রাখুন সুরক্ষিত রিটায়ারমেন্ট প্ল্যানের সাথে। সবার আগে লাইফ ইন্স্যুরেন্স।
My lords, may I submit? My lords, he is relying on two antecedents, my lords. I am having the
There are
order
criminal
from the
antecedents.
trial court. He has been acquitted in those crimes.
Or everybody has been granted bail?
Everybody has been granted.
But Your Lordships, he cannot claim parity because he was the one who took out the knife from his possession and stabbed the 3 victims.
He's in jail for the last 3 years.
3 years he's been in.
3 years, 24
And there is, Your Lordships, recovery of knife from his
So 3 years.
149 is also there. So there is a question of you're saying others are off. He's the only one who's to be picked upon.
Lordships, in the FIR, he has been.
You just file a counter. These counters that you file, as if we are trying the case. We are not concerned with the merits of the matter, whether he's guilty or not guilty.
But
You
Your
need to tell us what needs to be considered at the stage of bail.
But Your Lordships, his
That you
conduct
don't.
can
You
be-
give us details of the attack. He did this, he did that.
Your
What are
Lordships,
we,
his conduct has also to be seen.
for what
all
reason?
the-
We are deciding his guilt here.
But Your Lordships, he is the one.
It is a 149 case, we already told you. Where is the question of you're saying that man stands on a different footing, this man stands on a different footing? All other accused are on bail, is it?
all are not.
Given the fact that the petitioner has already suffered incarceration. pre-conviction incarceration for over 3 years, and it is not denied that all the co-accused have been granted bail, we find no reason to continue with the incarceration, continue the incarceration of the petitioner at this stage, the appellant at this stage. We shall accordingly be released on bail in connection with FIR number so on terms and conditions to be fixed by the trial court. We shall cooperate with the trial and not take unnecessary adjournments.
Grateful.
Victim is in custody since 25th September. It's 7 years. The issue is whether it's a loan or not. And charge was argued.
Your discharge application is pending.
Charge was argued on 19th February. The court is vacant. Not and they admit that. They admit this fact. I'll just show you lordship as a counter evidence for the moment.
Yes.
The only cases that there is kindly to see not counter affidavit para 10 at internal page 6. Para 10 internal page 6 of the counter affidavit.
Yes.
Thereafter, discharge filed by the petitioner was heard on 19 February, kept for orders. In the meanwhile, presiding officer was transferred till date with court of the special judge is vacant lodged about a year, and it's a 7-year punishment offence. And the issue was even the complainant admits in the illegal Panchnama that there was some issue of loan that he was returning.
He's not been inside even for a year, Mr. Mukherjee.
11 months.
Caught red-handed. 25th September
It's
24.
almost not, we are now in August.
So not even a year yet.
Not it's a section 7 offence. And I'll just show you lordship one thing.
Caught red-handed.
I know, Lord, but let me show you something.
And taking money from the contract.
My Lord, just see one thing. What does the contractor say?
Workers.
The contractor says that it is an issue where there was, we just come to their charge sheet at page, but charge sheet will begin. P5 would come at 64, please.
There's no officer, is it? Judicial officer has not been appointed.
Sorry?
There's no officer in that court.
But just see, yes. No,
Granting bail at this stage. Pending. Keep it pending for a while.
But may I just show you lordship?
Is that no officer has been posted? Criminal courts are not normally kept vacant like this.
Special courts not so broad. It's very unusual. It's unusual.
Notification is
If
required.
it's some additional charge, something should be
No,
done.
not because there's a notification required under the special.
Oh, I see.
In the PC Act.
But not, it can't be 5 months. It's 5 months, no, 6
Yeah,
months.
February he limited office. No, but find out why the post is being kept vacant. Counter affidavit has been filed. However, we find therefore that no judicial officer has been appointed. What is the name of the court? Special court?
But I'll just tell you, it's special,
BI is
first additional, I'll tell you lordship. But just a minute. First edition, second additional in district judge.
Second additional district judge?
Districts and
Some
session.
special court or something?
Special Court Anti-Corruption.
Just give me a moment, Lord, I'll just do so.
Special Court Anti-Corruption and CBI.
Special court, anti-corruption and CBI. That there is no judicial officer in the court of so-and-so since 19 to 2025. Then counsel for the state shall assert it as to why
The second edition.
no steps are being
But
taken
I'll give a lordship.
for appointing. Till date. File a status report as to why this court is being kept
I'll give
vacant.
you a lordship the exact rank.
We give you a short date, but can't keep these courts vacant like
Ma'am, this is the judge. This is the judge, right? At the bottom.
this name of the court.
Name, Lord, I've given it the notification.
Note the
Bottom, I marked it.
list on 28th August.
Lord.
28th.
7.
Please, your lordship. Your lordship, this
Counter affidavit?
Please,
No counters filed?
its counsel has been filed.
It's been filed.
When you have filed,
I don't have it.
Because unfortunately, maybe it's not on record, my lord, it has been filed.
You filed it yesterday.
So
Yesterday I was
Not filed a counter, 11th August.
my lord, I am apologizing.
Mr. Mananda.
No matter what.
My lords, in item 7, there are 3 matters. I appear for the state in the first matter. I filed my counter yesterday, so it's not on.
Not come.
But in other 2 matters, my lords, the department in its wisdom has not allotted the same to me. If I can get a week's time and get instructions on all.
What have you said in your counter with regard to these people? Have they been identified in the test identification?
Number 1, my lords, that the informant has refused TIP. Now he's afraid of
Refused?
whatever. He's refused to participate in the TIP. I've said so in my counter.
Informant.
Informant has refused. Yes.
Oh.
So that is number 1. Now, we don't know if it's out of fear or whatever it is. From the petitioner in item number 7, recoveries of 500 grams of the stolen silver have been recovered on the basis of his confessional statement from 2 other co-accused and the motorcycle. For 7.1 and 7.2, my lords, I'll still need time for instruction.
Your Lordship, this is a wrong submission. The recovery.
If you need to file a rejoinder, do so. We've received a copy of the counter.
False submission. 330.
We don't have the counter before us, so there's no need for you to argue. We won't retain whatever you say also.
I file rejoinder.
It is stated that the counter has been filed in
Yesterday in item 7, my lord.
in SLP criminal number 9655 of 2025. However, we do not find the same on record. Registry shall verify and ensure that the same is placed on record by the next date of hearing. Rejoinder, the counter, if any, may be filed by the next date of hearing. Counters may also be filed in the connected matters by the said date. How much time will you require, Mr. Manas?
Last 2 weeks, I'll do every.
3rd September.
3rd September. I'm grateful.
Item number 8.
Wait.
Lord, we have filed a counter.
Counter. You asked for time to file a counter.
Yes, today morning we have filed.
You filed it, received it. The reason why, in fact, it would have been better if you had not filed it, because we wanted to tell you what we want your counter to address.
Oh, my lord.
These young children in these schools,
Right.
we wanted to know whether there's any, what should I say, curriculum prescribed by the state to impart sex education to them.
Yes, my lord.
Will you do that?
We'll
The state
refile.
government insists on sex education being provided to these young adolescents. Do you or don't you?
We'll have to check it.
That will have to. And that is the reason why we entertain this matter, because these youngsters, they don't know what they are doing.
Right.
You don't impart any education, taboo at home.
Absolutely.
They don't know anything. Hormones are raging. God knows what happens. This young girl at 14, she's pregnant.
Pregnant, my lord.
Yes.
What happened thereafter?
He's in custody. Abortion.
No, not the boy. What happened to the poor girl?
There was an abortion, and
Abortion.
on that only the FIR was filed. 2.5 months.
Is it an actual case of rape, or is it just two youngsters
Actual case
indulging?
of rape.
It was an actual case.
Yes.
Anyway, that we'll consider, but we are more concerned. There's another case today again. Youngsters, same issue.
Since 21, we will file a better counter.
File an additional.
Bring out
Though the legal counsel appearing for the state,
We may be in the meantime. Will not, in fact, we have.
that a counter was filed today morning. We are of the opinion that an additional counter affidavit would also be required to enable the state to inform us as to whether sex education is provided as part of the curriculum in the schools within the state of Uttar Pradesh, so that young adolescents are made aware of the hormonal changes that come with puberty and the precautions that are required in connection therewith.
But in the meantime, even 2110.
He is anyhow in an observation hall.
I'm saying from 2110 to
We don't know what they've said in the counter. If it is actually a case of forcible
2 years,
sexual intercourse, then it's a different matter.
almost 2 years, my lord, since in custody, and even if it.
We'll give you a short date.
About 4 weeks. 4 weeks. Everything.
You also appear for the state, Mr. No longer appearing for the state anymore.
That is my change of heart.
No. But if you
Because earlier you used to oppose such cases like anything.
My lord, may see the
10 September. We'll take it up on 10 September, not too far away.
But consider to consider my lord, sir, to bail, consider bail application.
You go through the counter. You've also not seen what they've said.
Next week, my lord.
Rejoinder to the counter already filed, comma, if any, may be filed by the next date of hearing.
My lord, sir, consider this bail application next week, my lord.
Not next week. We'll consider it.
Other aspects, my lord.
We'll do the whole thing at one go. Go through the counter. If it's necessary, you file a rejoinder.
There is no recovery from me, No, at your instance, 16,000.
You took them to the house of Zakir.
The coactive disclosure, the person who has supplied has been granted interim anticipatory by the Calcutta High Court. Should we have the order? 75 and 76 page,
Who has been granted bail?
75 and 76 page.
What is his name?
Asif Mohammed, the supplier.
This is somebody else.
Yes, he's the supplier,
He supplied to Zakir Hussain also.
Zakir Hussain. And Lordship may have the order. He's been protected. But he said to serve notice upon the investigator refrain from taking coercive step against the petitioner. And I'm in custody for last 1 year and 4 months now, my lord. And similarly, place accused having granted protection, anticipatory protection.
Notice returnable on
So highly good.
10th September.
10th.
Service shall be effected by all modes including this.
This is also a case.
Let us hear some batch of
I put in
You've completed 6.
7.
6 plus.
6 years.
9 months.
6, 9, then it has come. That was the
Almost.
certificate 3 months back. Only thing is, there's something against me which I must bring to your lordship's notice. Lordship should be aware. He was granted a trial started in 2000. It's a 25-year-old matter. In between, it appears that he didn't appear, so he was taken back into custody. So then he was inside. Then he has been inside from 21 till now. He has been continuously inside. Lordships have custody certificate at 144.
When did he jump bail? During the pendency of the trial itself?
2003, the Lordship will have page 144 for a minute.
I see. The conviction came much later.
Yes, Milos, 25 years old matter, Milos.
Oh.
It's a 25.
So after he was caught there.
Does not now have the custody certificate. Just have that.
6 years, no doubt.
6 years, page 7 years.
Is he a person who can be trusted?
Because there's no antecedent. He's a
During the trial itself, he absconded.
It happened in 20.
Now he's got a conviction hanging over his head. Even more incentive to vanish.
For 3 years, because if the person could have been caught, he's caught with us. So if he has been caught in because what would have happened is 20 incident, 25 years old. Someday he may not have appeared for me because the order sheet is not here. And this also has not come on record because it's only because I saw the custody certificate. I asked the learned counsel who was representing in the trial court. He said he stopped appearing, so he was taken back into custody.
Let us see how his conduct in prison.
Lordship may have some.
Issue notice, returnable on.
Grateful. Obliged.
17th September.
Grateful.
Service shall be effective. 11.
Please, Lordship.
You are for the response.
Yes, please.
You filed the application. Recall. Application for recall.
We have moved, Your Lordship. We have moved it for recall. In person of the liberty, Your Lordship.
You are the owner. You are the landowner.
I am the petitioner in the original SLP.
Rajendra Singh.
Yes, please. Yes, please.
Yes.
May please, Your Lordship. Your Lordship, the liberty was given to us because this was passed without hearing us. The crucial difference, the order is premised on Harjeet Singh judgment, wherein
They are not identically situated though.
Your Lordship, there was a statement made by the council.
Offered plots.
They were identical, but the payments were refunded.
Both of them are directed to be given back their money. One took the care and trouble to ask for interest, one did not. But other than the fact that
there is a categorical statement. There is a categorical statement by the council that nothing more survives in terms of that statement that it was disposed of. That's at page.
You can't pay their money and thereafter say you won't pay interest. You're the state instrumentality. We find no
I bowed
grounds.
down to that, Your Lordship, but the only thing is the statement was made by them that nothing survives in the writ which is annexed at A6. 864 order, Your Lordship may have.
As the petitioner in the special leave petition stood is perhaps an respond.
Liberty was granted.
Liberty was granted because, but this is.
Like,
Especially petitioner.
We've all been there. Planning website structures can sometimes feel like solving a puzzle. Instead of using a million different tools, simply brief AI with the details. You'll get a clear, structured sitemap in seconds, and you're ready to export and share it with your client. Now go design something you'll still love tomorrow.
হ্যাঁ আরে বলছি তো পেয়ে যাবে রিপোর্ট।
ভাই স্ট্রেসে আছিস?
স্ট্রেসটার আমি?
হ্যাঁ, আজকাল খুব রেগে থাকিস। এই নে তোর স্ট্রেসের সলিউশন।
আরে স্ট্রেসের জন্য কে কিছু নেয় ভাই?
আমি নি।
স্ট্রেসকে উপেক্ষা করবেন না। স্ট্রেস থেকে হতে পারে সিরিয়াস হেলথ প্রবলেমস। প্রতিদিন খান হিমালয় অশ্বগন্ধা, যা স্ট্রেসকে কম করতে সাহায্য করে আর হেলথ রাখে ফিট।
Unlawfully retained by it. Along with interest thereof. The application is accordingly discussed.
But may I just make one submission? Can the payment be made time bound? Because as per the order, they already had to pay and they filed the application.
They filed this application now.
With delay.
They don't pay, file a contempt.
I'm already entitled to 12% now.
Whatever was granted to Harjeet Singh, you'll get the same.
I'm okay.
So the position was taken on the 22nd of September 1995.
But you filed this 227 petition against an order which basically doesn't say anything. That is the reason why the High Court has granted you liberty.
But can you see only
But you need to decide what your remedy is. You file an Article 227 petition against innocuous order which appears to be in your favor.
Court says that I am entitled for 15%.
That is not an issue which can be decided in this petition, is it? That 19th February order, please look at what it said. It only said disburse the checks.
The court
give it to my son.
That my objections cannot be decided.
Yeah,
Can you see the February order? For a moment, can you see the 19th February order?
Yes, which page is it?
Page 75. So I filed an objection saying that the calculation given.
You can't file an objection to this application. What is the application for?
Don't jump to page 75, sir. Please come to page 74. What was your application? What was your case?
But my
petition for receiving the checks is taken up for passing an order. The petition is only for receiving the checks.
But my petition is just above this. Kindly see page 73 onwards. There are 72 minutes. I am saying that I am entitled for 15% interest, not 12% interest. There are 8 minutes. The calculation which is submitted before the learned executive court was on the basis of 12%. And whereas the learned reference court has given me the interest rate of 15%.
Then you ought to have filed an application for review of this order.
I filed this application, the court dismisses, and I went to the High Court, and High Court said that this order is.
Because your application, if it is not considered in its entirety.
That is my grievance.
So far as this order is concerned, this order only speaks of the dispersal of the checks. That's all.
Kindly see page 75 for a moment. Only 2 lines, not I'll read.
We can't travel beyond this order.
There is a question mark.
Kindly see.
Now the High Court seems to have given you liberty.
No.
Given you liberty, is it not?
No.
Of course it has. Petitioners are, however, left free to work out their remedies in accordance with the law.
And then there is only execution. I filed an execution. Execution is over. The learned executive court has decided the execution in view of the order.
You seem to have clubbed prayers here because the order reads to the effect that you asked for the check to be given to your son. Where did that come from?
That has come because the mother was not there, so therefore she has requested whatever checks are coming because they wanted to give that money. Whatever money was given, the son has taken on behalf of me.
For the court,
Lordship then permit me that I should file an application before the learned executive court.
No, district judge Birbham.
For 15% or 12%.
Birbham will have to.
So that has to be because the quantity 15% way back in 2001.
Notice
have to give it of the record. Please grant it. perusal of the record, dispose of. Perusal of the record reflects that the petitioners LA execution case. What is the IA number? It's not IA, is it?
Not execution number, not execution.
In that you filed an application. There is no application number also.
So there is no. It's dated 30th of November 2024.
Where is the date?
I stated in the list of date because the order was passed on the same day I filed an application and it was considered on 19th of February 2025.
Petitioners raised an issue in their pending arising out of LA number 40 of 1997 that they, being the decree holders, at the rate of 15% in bracket simple interest per annum, but the calculation is with 12%. But the payment was sought to be made by the authorities. The interest at the rate of 12% annually. The executing court of the learned district judge Bedvam Suri passed order dated 19/2/2025 without taking into consideration this aspect. Aggrieved thereby, the petitioners approached the High Court by way of CO number 1247 of 2025 and Article 227 of the Constitution, but the High Court held that they could not have any grievance with the aforestated order dated 19/2/2025 inasmuch as it only directed disbursal of the payments by way of checks. The High Court, however, left it open, left the petitioners free to work out their remedies in accordance with law. We are not inclined to entertain this special leave petition at this stage, but are conscious of the fact that the executing court of the learned district judge failed to consider the issue of interest raised by the petitioners in the execution case. We therefore leave it open to the petitioners to seek review of the aforestated order dated 2020. And any such review petition, if and when filed, shall be considered on its own merits, uninfluenced by the impugned order dated 9/6/2025 passed by the High Court and the disposal. Only that. We gave you liberty to file a review petition.
And give you this.
Item number 4.
Item 4. Yes. He was arguing.
Yes.
Let us see what he has to say.
My lords, so parity is the same, my lords. A3, A4 and A8.
Oh, you put up everything. Parity?
Parity is the same, my lords. A3, A4 and A8 were convicted, my lords.
All the same sentence.
Same sentence, identical sentences. A4 and A8 were granted bail on 22/07/2019.
What is the period of incarceration that he has actually suffered? Though?
Nearly 11 years, my lords.
That's not very clear because if you look at the...
It's there in the bail application.
You get page number 9.
Your custody is
page number 9.
9.
Relevant is column number 29.
10 years, 9 months, 9 days.
So, did you suffer any incarceration prior to the conviction?
That is there.
There's no mention here.
There is there, my lord.
Where?
Set off period is 961 days. My lord.
Period of remand set off.
Yes, sir.
960.
3 years.
And then you went into prison on 24/3/2014. Then again, December 2014, you were granted bail.
Yes.
And then you went back in
17.
That was in
2017.
2014.
So 7 years, 8 years here.
Yes, sir.
And then 961 days as a pre-trial.
And today 11 years.
10 years now.
Others were granted when they after 7 years.
He's A3, is it?
A3, yes, my lord.
We find from the record that the co-convicts of the appellant, namely A4 and
A8.
A8,
4 and A8.
Kumar alias Gopal and Ella Varasan alias Pandian alias Vallavan. Within brackets A4 and A8. उनके नाम के बाद A4 and A8, comma, who stand on par with him, were already granted bail by this court. Both of them are granted bail by
Same day.
in that view of the matter, on the principle of parity, the appellant Amul Raj alias Selvam is also entitled to grant of bail. We shall accordingly be released in connection with charge.
A3, my lord.
A3. Amul Raj is A3. On terms and conditions to be fixed by the trial.
Yes, discussion.
Yes.
Briefly.
One.
One. Where is the high school record? Where is the primary school record?
My lord, respondent number 1 has not filed the counter record.
No, state.
Counter is filed by R1.
My lord,
State has not filed.
My lord, we are appealing for a state.
But where are these documents though? Neither you nor respondent number 1 seems to have thought it appropriate to file them. The whole case turns upon your date of birth as reflected in either your high school record or your primary school record, both of which are not placed before us.
My lord, pass over, my lord.
You'll be getting it by the afternoon.
No.
Then? For what reason do you want to pass it?
My lord, the main counsel is held up in court number.
He's going to fetch it out of thin air?
Court number 3.
He'll be getting it out of thin air or something? We don't have those papers. Without those papers, the case can't go on.
My lord, I have no idea.
Is it a matriculation certificate? That also we don't know. Is it an admission in the high school?
It's a 10th certificate, my lord.
It's a matriculation. That's not how the order reads also.
My lord, kindly permit to file. To file rejoinder, my lord.
File a rejoinder to R1's count.
My lord, we will also file within 2 weeks.
If they don't file it, you at least file what this record is.
My lord, we will file.
When comes preparing for the state, seeks some time to file a counter affidavit. Rejoinder, comma, if any, to the counter affidavit filed by respondent number 1 may also be filed by the next day of approval. So, the omitment should be done in that regard by the next day. The primary school record as well as the high school record, which contain the contradictory, don't say conflict, which contain different dates of birth of respondent number 1 shall also be placed on, shall also be filed. List on 10th September.
My lord, our presence is marked, my lord, because we are unable to give in online.
Not the case.
We will give, man.
You can.
Please, my lord. In this case, my lord, the High Court has squashed.
My lord, in this matter, 1 minute. My lord, in this matter, mediation is going on in the lower court.
Mediation is going on. Where?
In the lower court, my lord. There are 2 other matters, my lord.
You have no instruction.
My lord, the order is here, my lord. We have brought the order also. The matter was listed for extension of time, my lord. Page 4, paragraph 3 and 4 will show, my lord. On there asking this was referred to mediation, my lord. Paragraph 3 and 4, my lord. And the next page, it is in Hindi, my lord. Last order is that this is sent to the court. They were asked to appear for mediation, and then it was sent to the court for extension of time, my lord. On 8th of this month, it was listed for extension, my lord. Court was not there, my lord. It has been transferred to some other court.
Where do you find 8th of this month, the date?
My lord, the 8th of this month order is not there because the court was not sitting time. And we were informed that this has been transferred to some other court.
The matter cannot be.
So there are three connected matters, my lord. We had filed two, 138.
You have no instructions, but there seems to be some order.
Melos, that is some other matter which is going maybe between the.
This is connected to this only, my lord.
7 of the impugn order. The entire proceedings have been paused, so how can they?
In one case, there are three cases, similar cases. So he's saying
the same
he's saying that litigation is going on.
Those are the matters that
If they want-
against my client.
What is your complaint number?
Because my complaint number was 14276 of 22, criminal case number 204 of 22.
What about this 2608?
In fact, my lord, I
It is a 138 matter that he has filed against my client.
Anyhow, let the mediation go on if you settle.
Fix a date, Melos, because otherwise.
Fix a date. We are informed that the parties are attempting settlement through mediation before the trial court, and the proceedings in that regard are still ongoing. Based on 24th September. फिर नहीं आएगा ना वेडनेसडे नहीं आएगा आजकल सब आ रहे हैं
Several matters.
आ जाएंगे
And so, item number 3.
That the respondent has not entered appearance.
Services complete.
My leave to appeal was dismissed. The ground that I have not.
You have no documents to show.
That's right. But unfortunately, what is overlooked is 139 and 118, where there is an initial presumption in my favor. In fact, the trial court decides to.
No, but how is it possible to believe that you have no document at all with
regard
to purchase of practice?
That's right. If I may only say, I placed it before the High Court.
No invoices.
No
invoices.
My 391 was dismissed when I placed that document on record to show that I have these invoices.
Why, so you filed it?
Yes, before the High Court. Unfortunately, today.
No, but why is it that you did not produce it before the trial?
In fact, the consistent view of this court is that I just have to prove the check. The presumption kicks in. 139 presumes that I have the check for discharge of legal vacancies. A suggestion, Miller. The matter may require a detailed hearing before the appellate court. I'm only requesting if your lordships can consider remanding the matter to the appellate court.
When was the service effective?
Yes.
When?
There's
no mention of
23rd of April 2025.
It was
then.
Kotak Solitaire invite only credit card. Get 0 forex markup, accelerated reward points, family lounge access and more.
Any holiday plans?
आर्यन को बर्थडे के लिए मोनाको ले जा रहा हूँ फॉर्मूला 1 दिखाने
मोनाको एक्सपेंसिव है हो पाएगा
Are you crazy, Tarun? Hotels, flights, tickets.
तेरे बर्थडे के लिए हम सिनेमा जाते थे रो तो कुछ ज्यादा ही उड़ रहा है जुड़ रहा हूँ अपनी फैमिली के साथ
जुड़ रहा हूँ Kotak Solitaire invite only credit card. Get 0 forex markup, accelerated reward points, family lounge access and more.
हौसला है तो हो जाएगा
Because as per the Himachal Land Revenue Act, Section 163, it provides that in case of adverse possession and title.
Concurrent finding.
Yes, exactly. Please consider
And you say that the land came to you from your ancestors on one hand, and then you claim adverse possession on the other. So you're not certain as to how it came to you.
Let me say this, Malak. All these proceedings went when there were restrictions during the COVID period. Just all courts,
every forum has held against you.
it's kindly considered they had no jurisdiction as per
Where is
160. Because once
you're not even certain about your own stand. You say it came to you from your ancestors on one hand, you say adverse possession on the other. There's no mention of how it actually came to you, how long you've been in possession, nothing.
not able to procure the documents for the simple reason.
Sorry, Counsel, with these kind of findings, we
During
can't.
the COVID restrictions, Manoj, please
We
have
can't
the dates,
really help
Manoj.
you.
Because it all started from 6 to 2020, Manoj. And the restrictions started thereafter, Manoj.
Your appeal was dismissed.
Unfortunately, you know the position better. You may prepare a note, give it to us, which will be part of our order. And then we'll make a request before Honorable the Chief Justice of India also, so that those matters which are already pending here, they can be expedited.
Unfortunately, means since 2017,
Correct.
that matter is pending.
Correct. So but here none has challenged the vires of this act.
Subsequently, amendments have been made, Lord.
No, and we are
In this
saying that
present
this particular provision.
Yes, Lord.
See, is it not transgressing Article 22 that you walk into anyone's house?
I will make my submissions, my lord. I understand your lordships that the point your lordship is examining in the larger perspective. I understand, my lord.
How, what? See, if a man is on the road, is one thing.
I completely understand if the provision of the act is
only that if he has consumed alcohol and is sitting at home. That's all. He is neither a drug peddler, or he's not a peddler, neither a stockist. He's just a consumer, that's it. And he's not creating any nuisance. What right do you have to enter into his house without notice?
Lord, I can answer. My lord.
Is it not violative article? We are not.
I understand. I understand. My lord, the provisions of the act is like this, and your lordship is right. Your lordship is right that it has to be examined in prospect of Article 21.
Correct.
I understand.
No, without even notice, you just walk into his house.
Because that takes us to the challenge to the vires of the act on the basis of constitutionality, my lord.
We don't mind doing it here. We don't mind doing it here.
But it would be rather better, your lordship, if your lordship decides this to once forever.
At least this portion, this particular provision, I have not dealt with there. Therefore, I can do it here. And I would not be precluded from doing it.
Actually, your lordships, I have been told, my lord, that on the last occasion, one question was raised by Honorable Justice Mishra regarding, and that question, according to me, is very pertinent, my lord. His lordship's question was that suppose somebody is consuming wine outside the state of Bihar, the border is porous, and he comes within the state of Bihar, and you put him to breath analyzer test. Can you prosecute him under Section 37? Even if it turns out to be positive, can you prosecute him? Because he has not consumed alcohol in your state, and your jurisdiction is not beyond the state. And that is how, your lordships, I can demonstrate in this particular matter that how the provisions of the acts are being misused.
Absolutely. And today, sir, may I also inform you that the entire police force of Bihar is working only for this offences under this act. There is none to take care of crime and order situation. That is the effect of it.
Lord, the act has been substantially diluted, my lord. Even for the consumers, there is no punishment as such. Though those who consume alcohol and for this particular matter, basically he is concerned about the departmental proceeding.
Oh, no, not only that. Second offense is conviction, if I correctly remember.
Second offense is... Lord, second offense is conviction, and even first offense has clogged the entire judicial process of the state of Bihar.
Absolutely. So therefore, it is only, I have discussed with my lord, in fact, when item 7 was going on, then I saw you sitting here. We thought we'll appoint you amicus in this item 17, but we are.
I don't mind to work in that matter also, Lord. If your Lordship so wishes, I'll surely assist your Lordship to the best of my ability.
Item 7, then we'll. Item 7 था ना?
Yes, madam. Item 7.
Item 7 तो मध्य प्रदेश का था ना?
Yes, madam.
तो फिर कब से रुकना है? कब से रुका है? तो वो तो अलाउ कर देते हैं. तो just we'll allow it, ma'am.
Interim is operative.
Interim.
Yes.
Yes, allowed. So item by when do we?
Lord, next week I'll have some difficulty, and since I have to collect data, etc., your Lordships have said, I'll ask for time for 2 weeks at least.
Okay, and propose issues and proposed, whatever we can do. You just I'll note and we'll put it.
I'll surely do that. I'll surely do.
Shall we record your presence or shall we say amicus? Okay, presence.
In this case, Lord,
correct. List on as prayed. We have requested Shilpan and senior advocate as also, what's your good name?
Manish Kumar.
Manish Kumar to provide certain information for the next day. List on put it in here. 2 हफ्ते के बाद Tuesday.
Lord, State Council may also provide the data and the figure because they have all the statistics.
I'll try to collect because some data is already there that has been given in some other matter.
Are you here next week?
Next week, your Lordships, I have some difficulty. Lord.
No, we'll have it any day. What we'll do is we'll have it this Friday.
Lord, I will just request your Lordship.
For data.
Friday is perhaps 15th August.
Some more time may be given, so by data may be collected in a correct process.
NIC से मिल जाएगा. हम ही बोल देंगे ना data. आप ही बोलिएगा. What we'll do is हम इसको Thursday को रखते हैं. List on Thursday. Thursday.
Yes, your Lordship.
Just give the data and then.
And permit me, Lord, to join virtually if.
No problem.
Data with respect to pending excise cases.
Correct. In Bihar.
At all levels.
At all
levels. Thank you.
In this case, so far as I am concerned, I was a protected tenant.
Who is in possession?
I'm in possession. That is because they filed even a suit in 2007 saying that for injunction, and the court said they are not in possession. There is a direct.
Delayed by injunctions.
Please,
so delayed by 10 years.
That's what I don't know. That is, of course, one area which I have to point out to your Lordship. What has happened in this case? So there was preemptory order in 2010 that in case some LR is not brought on record, it will be automatically dismissed. Thereafter, there was no communication, there was no intimation, and thereafter, only when they filed a suit.
10 years delay is not explained. That's what we are saying.
Yes, ma'am. And they filed a suit in 2007 for injunction. The court found that they are not in possession. I have produced that order.
We are only saying what is the.
I'm sorry, my suit was dismissed on the ground that the writ petition was pending before High Court. When writ petition is pending before High Court, where there is status quo order, I cannot give any such order. That was the reason for which my suit was dismissed, not for on the merits.
Kindly come to page 110, Manoj. The finding recorded by the civil court. Page 110.
For the 4th round of litigation, your Lordship, the material point is on 1374 RU a tenant. It's a law. One must be tenant from 1374. If he is not there, from 53 till 74, he is not.
What are you?
I'm the purchaser from the landlord, your Lordship. Now I'm in possession of the land.
110, your Lordship may kindly see the finding. No, but this is because your Lordship may kindly see, so far as I am concerned.
10 years delay is not.
10 years delay, my lord, your Lordship will find I have given sufficient cause, my lord, your Lordship may kindly.
You don't find. Sorry.
Your Lordship may kindly see I have given because it is only when the suit was filed in 2007.
Sorry, ma'am.
I got the summons from that, my lord. I came to know that there is a dismissal of this.
Sorry, miss.
So your Lordships are dismissing on the ground of delay?
We are not interfering. That's what the courts have held.
Well, the court has gone on the merits of the case also because agricultural, my lord, person who had admittedly he is in possession, my lord.
Sorry.
Because even the court has recorded the finding that I am in possession.
We are only saying dismiss, that's all. Thank you.
There is a relent tribunal order which is in my favor, my lord, partly.
Yes, we have seen that. Thank you.
Grateful, boss.
19, we are being led by the SGs in that suo motu matter concerning summoning of lawyers. Both parties have filed written submissions. An interesting question of law whether the Government Grants Act would apply or the Rent Control Act can be used to in fact override the conditions of the lease itself.
Correct.
My lords may have it on some day because the SG wishes to address. There might be some discussion between a 4-judge bench judgment and a 3-judge bench judgment. In fact, a perusal of the impugned order of the High Court makes it clear.
Correct.
Question of law that may have to be decided.
Learned SG we know is very, very busy.
Lord, there is a status quo operating against us.
But we want to decide.
Absolutely, Lord.
Because the status quo has to be there, otherwise I am put out of that property. Government officers are occupying that.
Yes, Mr. Patwali.
But I am here to assist your lordships.
Oh, certainly. Yeah. Today, we are told SG is busy. You do one thing. You check up from the learned SG.
Please, my lord.
Whatever date and time suits him.
Correct. Absolutely. Correct. Let it be one. Certainly, as per my lord's board.
No. See, 2-3 times it has been adjourned only on him.
Please, my lord.
So you tell him, be it 10:30 or be at 4 o'clock, doesn't matter. Or even thereafter.
Correct.
Whatever date and time suits.
That way, we also have some certainty because some judgments will have to be read, and so you just go on reading and then.
An important issue.
Correct. Certainly. I will take instructions and I'll inform.
We'll just pass it over. So let us know, please.
All right.
Great. At 2 o'clock, we have the other matter.
Correct.
Yes, when I appear, the petition in this matter letter is circulated.
Shri Miss Mallushri Pathak, who is to argue the matter, is not attending court work on account of personal ailment.
My lords may give a shorter date, 2 weeks.
Yeah.
When she has fractured her leg, I'm seeking 6 weeks' time in this matter, my lords.
My lord, since 1 year this matter is not reaching, and since April they have been moving adjournment letters.
Lawyer's leg, fractured leg, what do we do now? Tell us.
My lord.
Based on after 6 weeks.
What's your pleasure?
6 weeks.
6 weeks, she's.
Second week of September, he says.
If it can be on the 10th or the 11th of September, the reference will also be over by.
You tell us.
Well, the 11th of September, anytime.
Based on
11th is Wednesday.
The password.
Thursday. 11th is all right because there will be less miscellaneous in any case on that day. 11th is all right.
11th of September.
High up, Kardi.
High up. Great.
Pleasure.
Item 21.
Maybe please. It's an interesting question, but before I begin there, I must say not as to what stands in my way. What stands in my way is an clear dismissal of my 11 by this court and a review being dismissed. But having said that, if your lordships would look at just one glance at the order that this court had passed on the previous 11, I'm sorry, which is Mishra. On the previous round, it is my respectful submission and humblest submission, not that view that this court took is completely contrary to a long line of judgments prior to that and after that. Please kindly have the first round. I must get over that before I invite lordships to not consider the question that's arising here. Kindly come to Lord Beach.
Even if it's a wrong view, in between the parties it is binding.
But
you may find a review.
I could have understood. I did. May say,
otherwise, there will be no finality in the
may I say this, Lord?
party.
I could have understood if it was not an 11. This was a judgment on merits. I could have understood. In which case, what the parties are bound, inter se the parties, it binds them. This is a 11 order, which is not only a referral order. It's not deciding anything on merits. And therefore I submit that that principle, it is my understanding, may not operate here. That because there is no res judicata. There can be, really speaking, bar in that sense. Why I say? Because it's only a question of reference. And nothing has been decided. Nothing has been decided by the 11th court. Nothing has been decided by the arbitral tribunal because the tribunal was never constituted. Can I just invite the court into the first round? Kindly see about the order.
No, are we to reopen that?
But bear with me for a moment as to why I say, for an order that is wrong is not even res judicata. Lordships have held that in my favor. So, but not just, and more so when it is 11. It's not a judgment in that sense.
Unless it suffers from inherent lack of jurisdiction.
But, may I say this, not?
If it is inherent lack of jurisdiction, you may argue.
I bow down.
But when the court had jurisdiction to pass that order.
But in an 11, your Lordships are not deciding anything. Can I just formulate the point? There's something interesting, and I say so with respect and responsibility. I'm conscious of.
Women, please don't say that there is a point. Yes.
So therefore,
but no, they are not inclined.
Can I just try and canvass the point?
Certainly.
I'm deeply obliged. Kindly come to 196.
What is wrong with the order? You first tell us that.
Precisely, Lord. Let me begin by first dealing with the stumbling block, which is the first round. Let me begin with that.
Correct.
Before I invite you to the impugn order, because if I don't get over that, there's no question of Lordships going into the impugn order.
Correct.
Please kindly come to annexure P28, 196.
Correct.
Now kindly see about 17. Paragraph 17. This is...
Straight away come to para 18.
I'm going to show para 17 and 18.
Okay.
17, 18 and 19 is what I was going to read to the court. What can I read from 17 or Lordships want me to go to?
No problem. You read the way.
17 I'll read, Lord.
सारे प्रोटीन्स हाई क्वालिटी नहीं होते. गोल्ड स्टैंडर्ड परफॉर्मेंस के लिए चाहिए ऑप्टिमम न्यूट्रिशन गोल्ड स्टैंडर्ड 100% वे. इसका मेन इंग्रेडिएंट है वे प्रोटीन आइसोलेट. एक्सेस कार्ब्स, फैट्स और लैक्टोज को वे प्रोटीन से आइसोलेट किया जाता है. इसलिए होता है फास्टर एब्जॉर्प्शन और मसल रिकवरी. गोल्ड स्टैंडर्ड परफॉर्मेंस के लिए ऑप्टिमम न्यूट्रिशन.
आगे नेब राज्य धन तारपर शासन.
ইস চিনি এই আসল ধন. জিরো অ্যাডেড সুগারে ভরবে মন. বিস্ফাম পেটিট ব্যুরো জিরো অ্যাডেড সুগার খাও মন ভরে. 250 গ্রাম কিনলে 30 গ্রামের হাফ সম্পূর্ণ বিনামূল্যে.
11(6)(a) is agnostic of any factual inquiry. The limited window that there is to see whether there is an arbitration agreement or not.
See, when you read para 80.
I'll read it.
Now read para 80.
Deeply obliged. In the instant case, the facts are not in dispute that for two incidents of fire on 25th September and 25th October 2013, the appellant company, based on the surveyor's report, sent emails on 5th May 2016 and 24th June 2016 for settlement of the claims for both the fires dated so-and-so and so-and-so, which was responded by the respondent through email on the same date, itself providing all the necessary information to the regional office of the company, and also issued the discharge voucher in full and final settlement with accordant satisfaction. Thereafter, on 12th July 16, the respondent desired certain information with details that too was furnished, and for the first time on 27th July 16, it took a U-turn and raised a voice of undue influence coercion being used by the appellant, stating that being in financial distress, left with no option then to proceed to sign on the dotted lines. As observed, case in itself is not sufficient unless there is a prima facie evidence. This is the error, my lord, with respect. Unless there is prima facie evidence to establish the allegation of court.
Therefore, you have to seek a review or you have to file.
I did. I file a review. I file a review. But
so therefore,
whatever you are arguing, those have been considered.
Yes. With respect,
para 79 of the judgment.
My lord, with respect, with great respect, what you lordships see, my lord, just kindly bear with me for a moment.
We understand that it is unfortunate for you.
Well, may I just say this? Please see, in view also. But in view of, I'm conscious of it. But there is something that lordships would want to consider in my respectful submission. 17, 18 and 19 is a clear error. But kindly see, it's a question of not, at gate itself, I have not been allowed in. The proceedings haven't commenced.
Then file a suit.
But then please observe that. Because not, I can't be nowhere. In Boghara, your lordships held that it is triable. Boghara, your lordships held
Whatever 12, 14 limitation.
I'm deeply obliged. Please observe that. I can't be remediless. I may have a case, I may not have a case, but somebody has to try it. Somebody has to try it. You have sent me out at 11. I have no remedy under, to file a suit.
You can always say you've been pursuing it, qualified, that we will not allow that.
Now, please see, in view, my friend is right.
Don't give us that.
For a moment, just one more indulgence. Please have para 11, para 21 of the earlier round. Just kindly have it for a moment. See, I had marked that also. 214.
Yes.
And please see, in view of this observation, which court will entertain my suit? Para 21. In the instant case, prima facie, no dispute subsisted. After the discharge voucher being signed without any demur or protest, and claim being finally settled with accord and satisfaction. These are all findings with great respect, Lord. I can never approach even a civil court. And in an 11, when there is in the statute 6A, and there are judgments of this court saying that you have
just one. Page 215 order.
Yes, my lord.
Has you saw a review of it?
I did.
Correct?
Yes, I did.
Now, we are putting it to ourselves that review having been dismissed, now is it open up for a two-judge bench?
But if I
just
please, absolutely.
Is it open for us, sitting in a combination of two-judge bench, to reopen what has been said and...
With respect, there are precedents which support me on this. Your Lordships have reopened when Your Lordships found that there is some error. And it is the bounden duty of the court to correct it. But with respect, even it would begin with that, with great respect, Lord. It would begin with that. I can't go to a larger bench, not on this. The review was filed, dismissed. And there is a clear, if I may say so, Lord, there is a clear error. It's contrary to the statute. You Lordships see that, Lord. See, it's contrary to the statute.
Curative is yet another option with you.
In view of the subsequent judgment and overruling of
DMRC.
21 in subsequent judgment, now para 21 may not be that damaging to you.
Please observe that, so that at least the court below, the first court of the court of first instance, is not led by these observations.
What your Lordships are not told that after the review, after 1 year, he moved an MA also. In a disposed of matter, that MA was also dismissed.
But one thing is there.
And after 900 days of that, is this new section 11?
Now that you have spoken, one thing is there. We have closed the matter.
Yes.
But have we not committed an error?
May I point out to your Lordships why your Lordships did not commit an error?
Yes.
Your Lordships, as the law then stood, said that as far as an accord and satisfaction is concerned, no dispute survives now. Later on, the law said that under a section 11, all that can be decided is whether the existence of an arbitrable dispute is not there. But the court on merits in the Supreme Court judgment had ruled to say there is no accord and satisfaction, as my lords rightly said. What about the finality to the inter partes dispute? Principle of law has been set aside. The judgment has not been set aside. Neelima Srivastav says that the judgment remains, inter partes decision remains. What has been set aside is the principle of law.
Let us follow that we just remedial.
That's right, Lord.
There is a remedy.
I'm deeply obliged.
Should be a remedy.
I'm so deeply obliged.
There should be. According to him,
yes,
there is a claim.
Yes.
You say there is no claim.
No, my lord, Supreme Court has said. Supreme Court has decided. Supreme Court has decided. Supreme Court has decided to say.
For a civil suit.
Yes. No, my lord, but Supreme Court
wants to pay court fees.
My lord, but he can't take a certificate from your Lordships to go and sign
They are
it.
not certified.
Absolutely. He has to avail of his remedies, whatever are there.
If it is maintainable.
Yes, absolutely. That's for him to speak.
With greatest respect, it's not as if the later. With greatest respect, it's not as if the law changed later. The law was the same as in from 2015. 6A was in the statute. The judgment is contrary to the statute.
Suppose we'll say that you propose, you intend filing a civil suit.
No, that's all I can do. That's all, because there is no arbitration now. All I can do is file a suit, and this would not come in the way of my.
One of the Lordships please keep in mind, this court has held that there is no accord and satisfaction as far as there is accord and satisfaction, and the review against that has been dismissed.
Without evidence.
Manoj, all that I'm saying
Then
is
there is a plea of coercion, undue influence,
yes,
and fraud.
Yes.
Without evidence, while dealing with 11-6, we will record a finding.
Manoj, your lordships, right or wrong, have retracted a
trial.
There
is some
but
party
all that I'm
claiming.
saying is, Manoj, that
How can you throw any person out of the court without a trial?
Manoj, today there is a finding with a review order.
If there is no arbitrable dispute, where is the occasion to say that full accord?
Because
there is no undue control.
I'll tell you, lordships, why. The reason
matter of evidence.
No, Manoj, why it was said was because there is accord and satisfaction, there is no arbitrable
liberty to file.
Manoj, all that I'm saying is,
we can't close the doors of court.
I didn't say so, Manoj. I didn't say so. I am happy. Let him file a suit. I have no difficulty. Let him file. But it can't be that after a finding of your lordship with the review, your lordship says you are permitted to file a suit. That's all that there is a decision, right or wrong, with the review.
The language what
all that I am saying is because
what he will dictate, but what
because I should be left open to raise my objections. I am happy. Let him file a suit.
We'll say that all parties are at liberty to raise all.
Manoj, that's his statement that he will file a suit.
Correct.
And parties will be left open to raise objections, whether it's maintainable or not. Yes.
That's what we.
Because I'm sorry, but I can't go into arbitration. I can't go to suit. So what's my remedy? I ask myself.
When counsel for the petitioner submits that petitioner intends filing civil suit, enforcing his remedies, venting out his grievances and enforcing his remedies. Well, it is always open for the petitioner to do so. And should the petitioner file the same, the court shall decide, the appropriate court shall decide the same in accordance with law. All contentions, subject matter of
one more aspect,
and subject matter of the present petition are left over.
All contentions, including maintainability. I will raise an issue in law.
All contentions will include.
One more aspect. Section 14 of the Limitation Act. I should just make an observation because would come otherwise not maintainable.
That I will argue there.
All contentions on merit are left open to be raised by the parties. Suit. However, we clarify that since petitioner has been pursuing the matter before different forums, the issue of limitation in the suit shall not come in the
anti-petitioner. Well, our respectful submission is, why can I not raise this issue before the court concerned? Well, today I have a decision, a review in my favor, and an MA dismissed. Right, wrong, this court has done it. Well, let it be left open for the civil court to decide.
Not the limitation.
No, why can I not argue that it's not maintainable?
Not the limitation.
Manoj, he has, please keep 3 dates in mind.
One thing.
Manoj, after the review.
Just 1 minute.
Yes.
See, we were prima facie of the view that we committed a mistake at that time.
Right.
But only because our hands are tied up today. Perhaps.
Yes.
Perhaps. Or we are open to examine whether 2-judge bench can reopen.
No, Manoj, I'm not even going that route. I'm happy with the suit route. I'm just pointing out. I'm pointing out just one thing. I'm just pointing out one thing to my lords and your lordships, but then whatever order your lordships wants to cast. From the date the review was dismissed, he filed the current section 11 from which the impugned order arises 900 days later.
That's all.
Manoj, all that I am saying, no, Manoj, it is a point. Manoj, that is why I am saying. No, Manoj, with great respect. Manoj, if 3 years later he files a fresh section 11, can I not raise the issue of limitation in a suit? Even a suit would have been time barred. 3 years have elapsed.
Let it be adjudicated.
Manoj, let even limitation be adjudicated, my lord. Manoj, 900 days from the date section 11 has moved there.
We have committed a big mistake at that time.
Manoj, I don't think your lordship committed a mistake, but be that as it may, a review has been dismissed against that.
Thank you, Mr. Court.
Very well, my lord. Very well. Very well.
Most grateful. Deep reply.
Lordship, coming up after notice.
Sorry?
coming up after notice, the only point is how that are.
Yes.
How the clause 25 is to be interpreted.
Yes.
There is a recent judgment on this.
Lordship, there's a recent, sorry.
Yes, which is the judgment?
Lordship, BGM MRPL versus Eastern Coalfields.
Citation?
Lordship, will just give me a moment.
2020 SCC?
Lordship, it's a... It's 2025 SCC online SC 1471.
Just 1 minute.
2025.
By Justice Narasimha?
Yes, Lordship. Exactly correct. 2025 SCC online SC 1471. It's civil appeal number 2141 of 2024. 21451. Pardon me, Lordship. Lordship, it's squarely on the point.
Yes, sir. Have you seen that?
No, my lord, I have not seen it. My lord, your lordship may just pass it over.
Lordship, the arbitration clause is at page 46 of the paperwork.
We'll then you go through the judgment. Yes, we'll also go through the judgment. We'll have
Lordship,
it next week.
Lordship, I have the judgment. I can read out the paragraphs. It's squarely on the point, Lordships.
Your lordship may have it Tuesday.
1 minute.
Let him read, Mr.
Yes, just read.
Yes, Lordship. I'll just read out the relevant portion.
Let him read it. Let him read at home.
Mr. Ganpati.
Yes, Lordship.
We will also read it and then we'll come back next week.
Not only he, we also.
We'll come back.
I'm sorry, I didn't see it.
Doesn't matter. We have to be. We have to keep ourselves abreast of the latest law or no. Next week.
Para 22, if Lordships will make a note, that's the relevant paragraph.
Para 22. Yes.
Legally.
Monday, Tuesday को दे.
Obliged, Lordship.
Tuesday high up कर दीजिए.
At 23, last time when the matter was listed, my lord directed them to take instructions within how much time they will make it.
Yes, there is a suggestion from my lords that there is a possibility of settlement. But I have sought instructions from my client. My lords, today we are paying a rent of 10,000 rupees per month. My lords, I have instructions to say that we are willing to pay a monthly rent of 40,000. We are willing to increase the rent to 40,000 from 10,000. Those are my instructions as far as the settlement issues.
We'll reverse the findings.
Well, then you kindly hear me.
Obviously, we'll have to hear you, but we are giving you our mind.
Well, I had put it to my client.
That's all right.
My instructions are that, my lords, as far as the rent is concerned,
he's not
increase the rent.
Yes.
It's as far as the issue, because this suit for eviction, my lords, which was filed by the landlord, it was
only on the ground of limitation.
Yes, it was dismissed by the trial court on the ground of limitation, my lords. The appellate court reversed that finding.
Correct, and the High
Honorable High Court has confirmed the finding of the trial court.
Correct.
Because the relevant provision is Article 66 of the Limitation Act. I was just kindly have Article 66 for a moment. Mary,
how would a limitation apply? I don't understand.
Eviction petition,
sorry,
the suit will be barred by limitation. And once it is barred by limitation, it is always barred by limitation.
For that particular ground, so if there is a fresh cause of action under
What
the
particular ground? If there is a ground made out under the accommodation control act or rent control, whatever. That's a cause of recurring cause of action.
My lords, may kindly
As long as the wrong committed by the tenant continues, it furnishes a cause of action, continuous cause of action.
No, my lords, what the provision of section 66 is that, because my lords may have considered the facts of the present case. My lords, what had happened, the eviction was sought on the ground that the tenant had constructed unauthorized permanent construction. So that was the ground. But this construction was carried out in 1984 and the suit is filed in 1998.
Correct.
My lords, may then kindly see Article 66 of the limitation.
66 is not between landlord or tenant.
Yes, my lords. My lords, may kindly see.
It's between the owner.
Yes,
and the person who is in wrongful.
But it comes under part 5.
His petition is not wrongful. His petition is not wrongful till he is evicted. A tenant always becomes remains in lawful possession.
That's true.
66 would not apply.
Well, let me just see. For possession of immovable property, when the plaintiff has become entitled to possession by reason of any forfeiture or breach of condition. Well, here the issues of breach of condition.
No. 67 will apply, Article 67 will apply.
Well, let's assuming 67 also applies. Now, let me kindly see 67. By a landlord to recover possession from a tenant, 12 years when the tenancy is determined. Well, in this case, there is no determination of tenancy by the landlord. Well, 67 there is.
How much time?
We told it.
Now, let's just consider on merit.
We are telling you.
They already sublet, my lord.
1 minute, just a minute. We are telling you, gentlemen. We'll just pass it over. Tell your client that we are allowing the appeal. Should you want time, we'll fix a time. No difficulty. Tell him.
I'll see this.
We are passing it over.
I'll come back in 5 minutes.
No problem. We'll also come back in 5 minutes.
Here he has misled the court. It says he raised a false plea before the trial. I would just demonstrate that because
don't argue on merits now. We have heard you. Question is only of time. If you want time, we'll give you reasonable time. No difficulty.
I'll see this.
Just be back in 5 minutes.
Yes. Yes, I've sought instructions. My lords will pass the order on merits. I don't have instructions to.
Please. Well, it will be in today's day. Allowed in today's. Yes, allowed in.
Only one point to mention, my lord, because he has already sublet that property to another
This is
person.
never
That I have already filed my additional document. That's the
This
I want to mention.
for the first time in the Supreme Court, these points are raised.
We'll direct you to revocate within 6 months. It will be a judicial order.
Great.
Grateful.
The subtenant is a party here? Subtenant is a
Subtenant
party.
is not party.
This plea was
Yeah,
never.
I'm just
This is for the first time before my lords are filing it, and yesterday evening they filed.
No problem. It will be allowed. It will be direction to vacate within 6 months.
Great.
Item 24.
My lords, in item 20, I'm requesting 2 weeks time to. My lords, I'm requesting 2 weeks time to file the rejoinder in this matter.
Item 24,
your lordship.
No, rejoinder for what?
My lords, by way of last order, your lordship has indicated that.
Have you seen the counter? Financial loss was caused and only 50% is recovered. That apart, you ignore his counter. It's a case of compulsory retirement and no recovery to be effected from you.
My lords have limited instruction. My lord, counter was filed on 4th of August, my lord.
We are ignoring his counter. Because you see, you have been compulsorily retired and no recovery has also been effected from you. And that order of the tribunal has been affirmed by the High Court.
My lords, kindly grant 2 weeks time to file the rejoinder.
Listen. Reading so it's lifted.
Well, there is a recovery from him. I just may point out. The High Court has said that there is to be recovery from him. The High Court says. The KSAT says there's no recovery. The disciplinary authority says KSAT sets aside recovery.
The second round said.
Second round. Interestingly, it doesn't challenge his finding of guilt. Only the state carries on recovery. He never challenges the finding of guilt by KSAT. So his guilt of negligence has attained finality. So he is here aggrieved saying that he doesn't have to pay the 8.5 lakhs. The High Court set aside KSAT saying there's no reasoning and no reason to set it aside.
My lords, a week's time for rejoinder.
We understand that you are appearing for. You are working in whose chamber?
My lords, the state of Tamil Nadu says private matter. It's private matter.
So we appreciate your anxiety and concern. We will not dismiss it today. Let the council be.
I'm obliged.
List on. Put it on in-queue question. Huh?
They're asking for rejoinder.
Rejoinder का जरूरत ही नहीं है ना. Have you understood what we have done?
My lord, listed on.
Why?
Main counsel should be there.
Because you are a young counsel at the bar, we don't want it to be on your.
My lord has been very kind to all of us. Very
My lords.
Next.
But same prayer, 2 weeks. My lord, 2 weeks time I am praying as a last.
No, my lord.
No, my lord. But only issue, my lord. Only.
No.
My lord, I bow down to what has fallen from lordship. The LPA was, my LPA of state LPA was dismissed for delay of 229 days, my lord. That was the issue, my lord. Main issue was 229 days delay So RL.
Even on the main merits, forget about the delay.
No, my lord. Apart on merits, I've got a very good case, my lord. There is nothing like that, my lord. Why I'm saying, my lord, the respondents herein have never faced any written examination, interview or something like that, my lord. They are claiming parity with the other persons who have qualified the examination and have been appointed under...
Village extension officer is the post.
Yes, my lord. Village extension worker, not officer.
That's
No, my lord, kindly bear me, kindly. My lord, it requires consideration. Kindly consider, my lord. Kindly see what
peculiar facts.
No, my lord, kindly
be
see.
treating as a...
My lord, kindly see for a couple of minutes, my lord.
Not to be treated as a binding precedent. Chaliye. Next please.
Lordship, the mediation is still
Mediation is in progress. Put it.
I appeal. I'm appearing on behalf of State of Karnataka and the proxy council.
The adjournment is that Lokayukta matter. Why did you take adjournment?
No, Lord, on the last day, I have moved the adjournment. Not on the last.
Why?
Last occasion, Lord, Mr. Povey had appeared and he expressed his inability to appear, Lord, this week. And we mentioned, in fact, Lord, the matter, and your Lordship says that.
List on को date दीजिएगा. Important matter है, इसको date दीजिए.
Lord, could it be in the second week of September, Lord?
No.
Your Lordship, Your Lordship, I only request. It's 19th of this month and 16th of September. You may kindly accommodate me on those 2 dates only, Your Lordship.
19th
August and 16th September.
19th August.
No, Your Lordship, I do not want on that
You
day,
don't
except
want.
on that day. Sorry.
In fact, Lord, Mr. Povey is traveling, Lord, from the 25th of August to the 6th of September.
Then you argue. Sorry.
Lord, may I just request, Lord, any date prior, Lord. Any date prior, I have no difficulty. Lord.
What date are you?
Tomorrow. Lord, tomorrow, not here this week, Lord. Next Tuesday, Lord. Next Tuesday, next Wednesday.
Tuesday is not available. Wednesday. Okay.
I'm so grateful.
20th.
Posted.
Yes, please. Yes, please.
I'm ready to argue the matter.
Time to file rejoinder. You have not filed rejoinder, but it doesn't matter. Argue. Last time it was only for that reason.
I'm rejoinder, but we are ready to argue the matter.
Do you want to file or not is what we are.
Very well. We will file it.
Then don't.
May I request, Milord, then let it be a last opportunity, Milord. But next day it is heard, Milord.
No, he is ready to argue, but he doesn't know what he will argue.
He wants to file rejoinder, but he is ready to argue.
Indulgently, we have last opportunity. 1 week time is done to file rejoinder. At least on.
As well.
My lords, I appear for the state. Yesterday only I filed the counter affidavit in the matter.
Ma'am, only thing is that there's a dying declaration and there's a child witness. What do we
This is
do?
a fifth case for conversion for section 304 IPC, my lord. It was a case of sudden fight. Secondly, my lord, I've already undergone almost 12 years in prison. And my behavior in jail is good, my lord. Page 85.
See, we can't do that. After 2 more years, you'll be entitled for remission.
Lord, page 85, custody certificate, my lord. My behavior is good, my lord.
No.
Jail.
Good people inside jail also.
On merits, my lord, it was a case of sudden fight, my lord. 304
Not a
IPC.
case of sudden. You don't strangulate your daughter-in-law in a sudden fight, huh? The dying declaration.
Lord, it's just that the brother-in-law and the deceased, they had some fight and got very angry and was burned. Service is complete. Service is complete.
Sorry?
Service is complete in the matter.
Please argue.
Your Lordship, we have instructions to file counter from the department, Your Lordship. Give us last opportunity to file the counter of Your Lordship.
The only thing is that 1 year is more, is in excess. That's the only thing. What do you say?
Your Lordship may give them time. We have instructions to engage the senior counsel in the matter.
Engage a senior counsel. Maybe we are sympathetic. Why don't you argue yourself?
Reduced to 1 year, 3 years.
Exactly. That's.
Lordship, please grant us 3 weeks time to file counter lordship.
You should only have sentence. That is.
Which one? I seek to short passo 31.
Aso?
Yes.
Aso will not come today. Anyhow, they'll stand as it is. Paso.
Lord, sir, granting Passover?
Right.
Who is to argue this?
Being led by Senior Counsel Mr. Shekhar Devasa.
Okay.
Please, Max.
My lords.
Yes, please.
My lords, I require 4 weeks' time to file the rejoinder affidavit in the matter, my lords. My lords, the petitioner lives in the remote village, so I'm unable to get in touch. So I request for the same, my lords.
Rejoinder 4 weeks.
Obliged, my lords.
Please,
Lordships, in item 33, just as a matter of housekeeping, item 33.6 and 33.7 don't relate to the same recruitment year and advertisement, and the issue is completely different. We are under old rules. And the rest of the batch of 33, even last time, your lordships, we had mentioned that, and lordships have agreed to segregate it. However, it didn't come in the order, your lordships. So we...
No, which is...
33 up to 33.5 are regarding women's reservation in the 2014 recruitment. 15. Ours is 2011 recruitment, and it relates to the publication of the second merit list. And it has nothing to do with women's reservation, your lordships.
No,
so 2 separate matters altogether, but same recruiting agency. That's the
which are the ones which are to be segregated?
33.6 and 33.7.
So what about the others?
Others, your lordship?
Other, I beg to appear in 33.2, which is though the main issue.
We just want to know, reservation apart, issue apart, what is the right? What is the right of the candidate?
Lord, the right of the candidate will be the carrying forward cannot be arbitrary. You have the discretion, but you can't exercise it arbitrarily. If I'm able to demonstrate to the court that yes, I had a right at that point of time and I was denied arbitrarily, then perhaps your lordship will be interfering. That's all. And I'll demonstrate it from the record that how arbitrary that exercise of power was.
Let's see.
Yes,
let's see what.
Yes, ma'am.
Your lordship, my only motion, the counsel for the state does not seem. I'm appearing for the commission.
I'm here, your lordship. I'm here, your lordship.
For the state.
Mr. Dwivedi,
I'm here, your lordship. The counsel for the state, your lordship. I'm here.
I'm sorry. I thought there's nobody in the.
Is there?
Please.
But whether it should be carried forward or not, the advertised vacancy is X, and they don't fill X, and then they come up with reasons which are not right. That's perhaps the common canvas in all these petitions. What Ms. Makhija is saying is perhaps for quite a different recruitment year. But that's all. A quite different RR. Maybe I have a different thing. I have something to say. There are inter alia issues.
All that we are saying is, let's begin, or do you want a date? Let's be very clear.
I don't want a date. It's not the question of me having a date. I'm just answering my lord's question as to what is the point. This is the point my lord is hearing it today. I'll argue it today.
Your lordships, I would like to argue mine because the issue is very short, because the rules provide that the second list has to come out. 2011 vacancies, your lordships, there's still 158 vacancies vacant, your lordships. It's a very, very short point. Because of this other batch, your lordships, my matter gets delayed as well.
Okay, then we'll segregate. No,
yes, your lordships. Lordships will segregate and finish mine.
My matter and Mr. Makhija's matter same. So item 33.6 and 7.
Yes, your lordships.
They have to be segregated.
Yes. Very, very short point. Even the High Court said come out with the second list. They haven't complied.
Retag kar dijiyega. 33.6 and 33.7. इसको कोई किसी
Tuesday,
Tuesday को
yes, Your Lordships, any
और just
at the earliest possible.
जो भी convenient जिस दिन को मैटर ना लगाओ और जो बाकी के हैं 33 से लेके 33.5 तक 0.6 हाँ 0.3 तक 0.5 तक इनको किसी उसके बाद ट्यूसडे को लगा
I'm very, very grateful, Your Lordship.
D-tag.
We have filed one written submission which is common in all your lordship. So that
No,
can
no,
be used.
you file.
We have already filed your lordship.
Written note of submission. 1 minute. Let fresh written submissions be filed in each one of the cases.
Very good.
Obliged.
Great.
It will be done
Within 1 week,
1 week.
we'll do that. Grateful, Your Lordship.
So, my lord, what I understand from my lord is this Makhija's matters have been fixed on X Tuesday, and my matters, which are different, are posted thereafter.
Yeah.
So great.
The Makhija's matter, my matter also.
Your matter also. So grateful.
May I please, Willis?
Yes.
I am for the petition, Willis.
Yes.
This is pertaining to a notification of Unified Bihar by State Public Service Commission for the Lower Division Clerk and Lower Revenue Department. Yes. Way back in the year of 1998.
Now kindly come to para 14 of the impugned order.
Yes, please.
What is your right? You tell us this. This is what the court has held, the division bench has held.
Yes, prior to that, may I come to the factual matrix of the entire matter, Willis? Because it is all pertaining to the same notification. Yes, Mills.
2004 note.
2004, Millers, the results have been published. And then after out of 59 selected and recommended candidates, 46 have joined. And I, among those very leftover 13 candidates have been
Why they were left? Because the formalities were not completed.
Formalities were not completed, Millers. The single bench has already given a verdict in my favor, Millers. And the notional appointment from that very date has been taken care of. That is the only thing which I am seeking.
What is the reason why these 12 candidates which were left out?
These are the administrative delay that will be better explained by the state ministers. They have not been in a position to attribute any such reason on the part of these very candidates, those who have been selected out of the same notification ministers. And they have been ranked higher as far as qualification part is concerned.
But would you be claiming seniority also?
No, Millers. I am asking the same notional position and appointment from that very date.
But minus the seniority and the monetary benefits.
Minus the seniority and monetary benefits, means.
Yes, so what do you say?
My lord.
See, point is very simple. Advertisement is the 28th of January 2004.
1998, Millers.
Sorry, 1998.
Bihar Public Service Commission, my lord.
1998.
Yes, my lord.
Correct.
Yes, my lord.
46 out of 59 were...
They joined the job, my lord. They were permitted to join. The 13 left over, my lord, was on account of verification, and the papers they have submitted before the Public Service Commission could not be verified on account of their fault.
1 minute, just.
Please, my lord.
We are only trying to understand the facts.
Please, my lord. I have prepared a short note, my lord.
The recruitment process started when?
My lord, my apologies.
Selection and appointments.
Selections advertised
in the year 1998.
2003, my lord. Please, your lord. 21st of 1998, we started with the advertisement, my lord, but yes.
Correct.
Yes, my lord.
Eventually, the names are recommended when?
Names were 2003, my lord.
2003.
Yes, my lord.
Out of whom, how many were recommended?
59 candidates, my lord. Yes, my lord.
46 joined.
Yes, my lord.
46 joined.
Yes, my lord.
On 28th of January 2004.
Yes, please. 21st of January 2003, my lord.
3 or 4?
Recommendation for joining was on 21st of March 2023, Millers, and they have joined on 28th of January 2024. 2004.
That's what
46 appointed. Yes, Millers.
They joined on 2004. Correct.
Yes, my lord.
These 12 candidates were also part and parcel of that very same recommendation.
Yes, my lord.
Now, you'll have to tell us on record, because the learned single judge is in their favor.
Yes, my lord.
The High Court says that they have no right to say
Very fair, my lord.
that please appoint us also.
Yes, my lord.
Perhaps that part may not be correct, more so for the reason that when they are not at fault, You have to, from your affidavit, show us how they're at fault.
My lord, they were not part of the same recommendation. They were recommended by in the year 2004, my lord. Earlier, the other 46 persons were joined out of 59 were part of the another recommendation, my lord.
No.
Whereas
Why were they not recommended is what we are asking you.
Yes.
When the selection, advertisement is one.
Yes, my lord.
Examination is one.
Yes.
Selection process is one.
But may I clarify? I'm for private respondent. May I clarify some facts?
You are a private respondent.
I am for private respondent.
I
am part of that 46 people who are recommended in March.
Your interest has been protected by him. He says he doesn't want seniority over you.
Only with respect to what is falling from your lordship.
Okay, no problem. You tell us.
Yes. Lord, what has happened that initial recommendation took place in March 2003. Thereafter, my lord, appointment happened in 28th of January 2004.
Correct.
Thereafter, my lord, their recommendation, so their recommendation was concerned, that was withheld by state because of, my lord, more than one reason, my lord. What has happened that these were people who belongs to one district in Jharkhand and their roll number was consecutive, they all were close relative. In fact, there is a glaring fact, my lord, where mother and daughter both had taken that exam, my lord, and the age difference was of 5 years. So in that view, the state of Jharkhand, my lord, initiated an inquiry into all these aspects, that as to what has happened, what has caused their role.
Then
it has happened, my lord, in 2000, after my recommendation itself.
Then
in 2003, my lord.
But then ultimately in inquiry, they were absolved.
Thereafter, my lord, inquiry happened and they were recommended in July 2004.
Therefore, the apprehension or the allegation were found to be incorrect.
So far, so state is concerned, yes, my lord. They were absolved, my lord. But there has been an intervening fact also, my lord. One notification came in July 2004 where, my lord, LDC and UDC posts were segregated. So UDC became a promotional post. UDC was a direct post. Now it became, earlier to this, my lord, it was a direct post. After this notification of July 2004, LDC was segregated from UDC and they did not challenge this notification. This is one, my lord. Second, my lord, when their recommendation happened in 2004, till 2008, when they are finally appointed, they were sleeping, my lord. They never approached court, my lord.
Wow, they have been recommended in what capacity now?
Lower division clerk, my lord. Lower
division, LDC.
LDC. In LDC.
Yes,
my lord.
You are in UDC.
Because my appointment, yes, I am in UDC. I am in UDC.
May I submit bills? May I submit to this bills?
You will have to explain.
Yes, my lord. I've already explained. Kindly see page 4, para 8 of my counter affidavit, my lord. The following facts are contended by the respondent 1 for better appreciation. Bihar Public Service Commission, by its letter dated 1092, dated 31st of March 2003, had recommended for appointment of only 49.
Their mistake.
My lord, I am not saying their mistake, my lord. They do not have any right to claim that they should be appointed once they participate in advertising.
Why did you then?
I'm coming to that, my lord. I'm coming to that. Subsequently, I'll come, my lord. What I'm saying that, my lord, their fault is that their conduct was itself under question, my lord. Their papers, the application forms were
You did not cancel their candidature.
No, my lord, I did not cancel.
Therefore, your conduct will not come into the picture.
My lord, before making an appointment, my lord, I have to verify each and everything, my lord.
So if there is a negligence or delay on your part.
Not my part. That what they say.
Where is that we are asking you? Please, in your affidavit, you say that there were any delay or lapses is attributable to them, is what we are asking you. We are only asking you this.
Yes, my lord.
You will have to say in your affidavit.
My lord,
The High Court doesn't deal with this aspect.
my lord, yes, my lord, High Court has not gone to kindly give me 1 week time, I will file better affidavit on this. My lord.
We'll record your statement. You don't claim seniority or arrears.
Yes, Millers, only one submission. In pursuance to my learned friend's submission, these very completely incorrect facts what they are trying to mislead as far as the private respondents are concerned. They are saying about 10th of July 2004 demerger notification.
Forget about what the private
Yes,
is
Millers.
saying.
Yes, Millers.
Are you ready to make that statement?
Millers, I am ready to make that very statement to that very extent that joining with notional appointment as far as the single bench order is concerned, that should be complied. That is all. I am not seeking any arrears to that very effect, Millers.
Sorry.
That very statement can be taken on
Seniority will be the issue.
at par with that of the people, those who have joined in 2004, Millers. My very claim of
Seniority cannot be an issue. Anyhow, you take instructions. Why make a statement today?
Yes, Millers.
Take instructions.
My lord, in fact, before LPA bench, they have already waived off seniority. This is.
He has to make a correction or no?
I already.
The state filed an affidavit explaining the delay stroke latches, if any, attributable to the present petitioners in issuing the letters of appointment with regard to the very same selection process in relation to which the private respondents stood appointed on the 28th of January 2004. When were you appointed ultimately?
2008, Millers.
We noticed that the instant petitioners were appointed
28th of January 2004.
only on 29th of April 2008 or
January 2004. 28th of January 2004.
You were appointed when?
2008. 29th of April 2008.
29th of April 2008. Whereas the private respondents were appointed on 28th of January 2004.
You also giving any returnable date?
We are giving a date. Affidavit within 3 weeks. Rejoinder 1 week. List on.
Grateful, Your Lordship.
Your Lordship, we're being led by Senior Advocate Ms. Anita Shenoy. She is on her legs in court 1 and will be seeking a passover.
Passover.
Wait, please, Lords. Lords, this was a partition suit. Lordships had issued notice in January of 2024. Thereafter, we filed the process fee. The process could not be issued, and therefore I had filed an application seeking Lordship's permission so that.
What is the error? You tell us that.
The error, there are 2-3 major errors in the impugn order. That's perhaps made with the court when the court felt like issuing the notice on 24th of 2nd of January.
You have been given 1/3 share.
Yes, my lord. According to me, the respondent number 1 and 2 are not entitled because the succession opened in the year 1939. That's when
they are your sisters or no?
They are not my sisters. They are sisters. They would be sisters through the grandfather, great grandfather.
Whatever it is, they are part of it.
And one of them is not even a sister because she was not the daughter of the alleged daughter of my great grandfather. So therefore, she could not have claimed. I have raised that defense in my written statement. And there are 2 aspects to it.
And Kanhaiya Kumar had one son, Gajendra Pandit, and he was married to Sumoni.
Sumoni.
Now, through them,
yes, Lord.
Through the said with law,
yes, Lord.
They had 6 children.
Yes, Lord.
3 sons and 2 daughters.
Yes.
And the plaintiffs are the legal heirs of.
Now that's the point, my lord. My lord has page E perhaps in hand. That's where the family tree has been given. Page E, my lords, has that. There are 3 crucial facts which my lords have just pointed out. Mr. Kanai, who is the common ancestor, passed away in the year 1939.
Correct.
That is before the Indian Hindu Succession Act had come. And allegedly after 1937, the Right to Women's Property Act had come. In this Paragana, that 37 Act was not even notified. That's why that's what weighed with the.
Whether you are entitled to 1/5 share or the plaintiffs are entitled to 1/5 share or 1/3 share, that's the only issue. The question is only of share, not entitlement.
That's what I wanted.
If that is it, so then why not 1/3?
Because that
According to you, according to you, they should get nothing. If we were to
that's why permit me to. There is a reason why I was drawing my lord's attention about the share only.
Gentlemen,
yes, my lord.
With regard to the entitlement, concurrently all courts have held they are entitled to.
Even if we take on the entitlement, the extent of entitlement, there will be an argument. And that's why I wanted my lord's attention at page E.
Sorry, sir.
Let's just kindly have page E for a moment, my lord. I will convince the court.
Thank you.
1939, when the act was not even in place.
Women have to be pleased.
I am not saying they are not entitled to. They will be entitled to 1/6 or 1/12 and not the share which is granted by the court.
Thank you.
Let's kindly have the page 18, which I have raised this fair and square the grounds.
Thank you.
Permission of your lordships, may I be allowed to withdraw the petition as the order of the Honorable High Court has been complied with by the state of Odisha.
Very good. Seeks permission to withdraw the present petition for the reason that the order already since complied.
Grateful.
Your Lordship, in item 38, the main counsel is still in court for
Your Lordship, rejoinder was to be filed. Rejoinder has been filed on behalf of petitioner.
It's only a question of disability.
Your Lordship, the main counsel is still in court for Your Lordship. Kindly pass over.
Your Lordship, I have to. Your Lordship, I have another matter in Gurgaon. It is only for the filing of rejoinder. I have filed the rejoinder.
We appreciate the innocence, but we must correct you. Arguing counsel not well. Okay. Not well for 4 weeks. 4 weeks.
Hello, I be respondent number 1 in this item 39, Milos.
No problem.
Item 40 requesting for passover, Your Lordship. My senior colleague is in court number adjacent.
ये passover तो बड़े हो रहे हैं. We are very indulgent, it seems.
She is all her legs, Your Lordship, in court number.
Tomorrow onwards, we are making it clear now. We will not no passover. If this is how the final hearing matters, you're going to take passover, then every matter is passover. Anyhow,
when you know that at 2 p.m. some other matter will be taken up,
No.
passover is in fact a prayer for adjournment.
Well, in fact, she is on her legs in item code 13.
ठीक है, passover कर देते हैं.
So grateful.
With respect to respondent number 1, the service is completed, Millers. With respect to respondent number 2, we've just received the affidavit today. We'll take it in due course. That's my grant me a week or 2's time.
No, respond number service report says not served.
Because respondent number 1 is served, Millers. The office report says.
No. Notice he left without instructions, unserved.
Because does the service have been served, Millers? Look at the office report.
Okay. As per office report, office report dated 11th of August 2025, respond number 1 stands served through Dusty service. Respondent number 2 not complete. His service core number 2 is not complete.
2 weeks time will be granted.
The reason being that the petitioner has not taken steps. So let the needful be done, now done, as preferred, now done within a period of 2 weeks, failing which the petition shall automatically stand dismissed from non-prosecution without any further assistance. In the event of steps being taken, notices issued, returnable time.
My Lordship, I am seeking crossover in this matter. We have been led by senior advocate Mr. Rahul Kofi. He's another.
एक है पास हो लीजिएगा.
Your Lordship, I am seeking a short adjournment. I am appearing for private respondents.
There is an adjournment today.
Item 43.
I have, my lord, in item number 43, I am entering appearance on behalf of respondent number 1. Though the office report is saying that he has been served on 20th of June, but actually he has been served on 28th of July.
How does it matter?
My lord, I am seeking 4 weeks time because he is not well. So he has not visited. I will file my wakalatnama on behalf of respondent number 1.
Steps, no, you are for number 1, huh?
Yes.
Now, what about 2 and 3?
No, sir, they are, my lord, they are pro forma respondent basically. So he is the only contesting party.
Respondent number 1 is the contesting party, whereas respondent number 2, 3, and 4 are pro forma respondents. Then respondent number 1 is permitted to file counter within how much time?
4 weeks, my lord.
2 weeks, 1 week.
Interim order may continue.
Interim to continue.
In item 44, requesting for a passover.
Pass.
Oh, but I am agreeing with the respondent, but instead of Passover, my lord, could also be some other day, my lord.
It will come some other day only.
Visualized.
46.
What's it?
46.
The fresh matter, my lord. Let's. The transfer issue.
Transfer now, you tell us.
So I'm only limit.
We want to help you. How best we can help you? Tell us that.
Because I'm only limiting myself. I'm only limiting myself to the impugned order paragraph number 12, my lord, the last paragraph.
What can be done?
I'm sorry, ma'am?
What can be done for you?
Lordship may come to the paragraph 12, bottom, my lords, last 3 sentences. Well, the High Court has overreached beyond the prayers of the OA as well as the writ petition. That's all I'll say.
So page 11. Page 11. You are the petitioner with the High Court.
I was the petitioner before the High Court. The respondent number 3 filed an OA.
1 minute. Last 3 9. He's only agreed with that.
That's fine. This should have been done, my lord. And she's a lady. And I work in the accounts department in Bangalore, my lord. All the head offices of the major institutions are in Bangalore.
You only agreed of this part of it. Yes, consider. You only agreed of this. Notice you're of this part of it.
Only that what my lord may state. That's it. I am not pressing anything beyond. Let the government take any decision. If anything, that will be subject to outcome of further OAs will be filed.
Of the directions issued.
Paragraph 12.
In paragraph 12, following direction issued in paragraph 12 of the impugned order. Here, page 11, -2-2. Notice confined only to this aspect. Returnable quoted. We'll say notice only to the state.
That's also sufficient. That will
suffice. At this stage, notice confined only to respondent number 1 and 2. Who's the standing counsel?
Mr. Raghuvar, I'll send it on them. There are a couple of them.
Trying to, in addition, see. The aforesaid action shall, in the meanwhile, shall remain stay.
That's the addition.
Justice.
Deeply.
Please, Lordship. Lordship, in this case, none has put appearance on behalf of respondent number 2, who is private respondent.
State your Lordship.
And
the possibility of settlement? No.
Lordship, respondent 2 has not put appearance, so how can it be settled?
So when what
Lordship, I have a limited prayer.
Yeah.
Actually, by impugned order, High Court has imposed a cost of 50,000 on both petitions. This is arising out of 2 quasi petitions, one against DB case and one against 125 case. So as the case was not decided on merit, counsel for petitioner has not appeared on that day, and matter was dismissed without hearing the counsel. So
वो वकील साहब नहीं थे ना अभी तो उसके सच Respondent number 2 stands served.
Yes, Lordship. Office report says so.
After office report, respondent number 2 stands served. None has chosen to enter appearance. Consider view that the impugned order needs to be quashed and set aside. For the simple reason that the petitioner, instant petitioner, was not informed. Adjournment was sought on behalf of the petitioner on the ground that the arguing counsel was not available. So the petition also, another petition was filed by the instant petitioner seeking quashing of proceedings instituted by the respondent under section 125 CRPC. Well, these cannot be the grounds for rejecting the petition filed by the petitioner under section 482 of the CRPC. So, in our considered view, the board also erred in imposing cost of rupees 50,000 on the petition. Such the forcing allowed order such that the direct the parties to appear before the High Court. The original petition and restored to its original number. Direct the parties to appear before the High Court on that. And on which and ensure to be
Any fixed day for appearance?
we are giving party we request the court to decide the petition.
This is the case, Milord.
We have seen your affidavit. You have filed an affidavit.
Yes, Lordship, in this matter, I am led by Mr. Naidu for the appellant.
Milord, one thing I wish to make clear, whether today or later. Milord, I don't want to say anything against any lawyer. Things have happened. It happens, Milord, a lawyer gets an affidavit. He believes an affidavit that's of a client and he files. I have nothing against the lawyer. Our simple plea is, Milord, whether in the vacations, the manner in which, Milord, our appeal was sought to be made infructuous by saying that we withdraw our writ, which had since been disposed of. We are agreed by that. We want the appeals to be restored here. But we have nothing against the lawyer. I am not interested in all that. So whether or not I will take
he was here in the first round, Lordship, and I know and
no problem.
That's all right. I am not saying no.
Lordship, may just accommodate me for today.
Yes.
Of course, we'll accommodate.
Lordship, keep it on 26th, Milord. That's a Tuesday.
Not 1 week later. Not 1 week later, if you not.
No problem.
And Lord, I have filed an application for intervention, Lord, for the purpose of because there is an allegation made against the son.
No problem.
Of respondent number.
Your application allowed. No problem.
Lordship, that application is 17162.
26 के बाद कोई जो
So, Lord, maybe then have it on 9th.
Your son of? Sorry, the respondent number 1, V. Kameshwar Rao.
His son. Because we are making an allegation against that son now. Because he, according to us, Lord, he is the man who did all this.
You want an inquiry?
So, no, Lord.
Why are you joining?
Lord, I want, because there is an allegation made against me and therefore I
welcome him. I am going to argue that.
Why are you Why should you?
Prove his honesty. Welcome.
Lordship may take up this application on the next day.
You don't want
to. Let it be allowed. You are welcome. Don't do that.
I am appealing for two lawyers who have given no.
No, just 1 minute. You are not here.
No.
Mr. Rodgi has already said that he doesn't want to agitate anything
against any law.
Any of the law. That the two lawyers be discharged. That's my request. Now, as he doesn't want to go ahead, so there.
Mr. Rodgi will not object if we proceed to.
There can't be any discharge till your lordships here.
We may proceed.
Court can proceed because
A wrong statement is
many
made.
things have happened in the past.
Is procured. So we may proceed against the law.
It is my request that
In the vacation court is taken away for the.
Yes, yes.
Lordships may decide.
There is no doubt, Lord, that there is somebody behind who has done all this. The lawyers may be. What happened?
because the lawyers will not.
Today we are not saying anything.
But all right. Next date.
Let the matter come on second, my lord, which is.
No, second, I have difficulty.
Ninth.
Ninth.
No, there's one preempt, if they want to.
But this is very rare when we are allowing the petition and he says, don't allow my.
He got it now. He realized it.
My
lords have given a clue to him. He given a clue.
No, I'm not making.
That's right.
Lord, on the record that I have.
Quickly fell from the bench. All the 3 wickets down now.
On a record, the record that I have before me, my lord, as a lawyer.
Ninth.
There are 2 other applications to which, if they want, they can file a counter.
But they are not filed as of now. In spite of the lordships, whoever wants to file.
Once again, recall application, the others are not let them.
Let counter be responsible
Other
for the application.
Very well.
Within
Lordship, please.
within 2 weeks.
Very well. Obliged. Right.
Please. Yes.
It is the motor vehicle accident number. Both the courts, my lord, they rejected the claim of the my lord, the
Why?
2 deaths, my lord, only on the my lord, the
Hearsay.
tribunal as well as the honorable high court.
Hearsay.
Hearsay because at 11:30 night is the accident was happened. 11:30
When did
night.
when delay also, no?
No delay. Delay next day they themselves is filed a complaint. 14th August 2013 is the my lord,
Then possibility of settlement.
No, my lords, both the courts have unanimously hold, my lords, that
We know that it is hearsay.
not even a single evidence.
PW1, PW2, both are there. Hey, 1 minute.
Sorry, my lords, I'm sorry.
You have an excellent case.
I'm sorry, my lords, I'm sorry.
We are only saying after all accident has taken place or no. He was 26 years of age.
Yes, my lords.
Some compensation.
one is 22, one is 26.
No, two people died.
22 one, another one 26 my lords. But the owner and the driver are not disputing the accident. They are not disputing. There is a FIR, charge sheet is filed.
1 minute. We are on your behalf. We are persuading him.
Because they ought to have filed then under 163A. They would have got rupees 5 lakhs each. They did not have to prove rash and negligent act. Now, my lords, today, not even a single evidence, my lords, is there, my lords. Both the courts have, my lords, have meticulously, my lords, appreciated the evidence that how the false witnesses have been created, my lords. PW3, PW4, my lords, comes up and say that we heard the owner and driver talking to each other on a bus stand. That he had hit the.
We have seen it there. We are only saying some reasonable amount you pay. That's it.
Because then I don't have instructions for that, lords. I'll have to seek the instructions.
Take instructions.
Yes, we'll do that.
Death has taken place. Accident has taken place.
There was an FIR against this.
FIR, exactly.
Not against this vehicle, my lords. Some unknown vehicle, not even the type of the vehicle has been identified as the FIR.
Charge sheet is filed, my lord, against the driver as well as the owner.
Had there been an FIR and lorry mentioned, type of vehicle, my lords, I would have mentioned.
Is there or no?
So charge sheet is there, but this judgment.
Vehicle is identified by the RTO. How can the driver be made an accused?
Lords, with respectfully, lords, I would.
Or is made an accused quite a vehicle.
Yes, my lords, he has made the vehicle, my lords. But my lords, then if your lordship permit me, my lords,
Don't worry, we'll of our own do it. Don't worry. We'll हम ही कर देंगे. हाँ. हम ही कर देंगे. We'll allow it. What is the amount? You tell us.
I'll just.
Lords, but
what is the reasonable amount?
My lord, one is, my lord, is working as a loan recovery agent, my lord. The another is a bar binding contractor, my lord.
No, what is the income which you?
What are the income? They said it. One, the loan recovery agent, the Mr. Sunil Singh, the 26 years old, is receiving 40,000 per month. The another my lord, the bar binding, he is earning 50,000. It was mentioned in the claim. The salary certificate also, my lord, the appointment order is
there now.
based on
Yeah,
record.
CAV comes.
Lords, with due respect, my lords, I would like to submit, my lords. This honorable court, my lords, have held, my lords, in Safiq Ahmed, my lords, that false witnesses are created, my lords, and now that this honorable court has.
Deal with your submission, no problem.
My lords,
We have to, in any case, reverse. When we are reversing the findings, we have to deal with the findings. Now you give your written submissions.
We'll do it that, my lords.
Let written submissions be filed within 1 week.
We already filed it.
File it again.
I'll file it.
Lords, 2 weeks, my lords.
2 weeks, no problem. All matters passed over, they will.
Well, items.
Permission to mention that matter. Mr. Sibbal is on his legs in items.
Sorry, we are not.
Lords had indicated that if Mr. Sibbal is in difficulty on.
No.
That matter is over.
No, it's going on. He is on his legs in court 2 as item 30.
No problem. We'll
Court 1. He said that he will be busy in court 1 in that advocate matter.
Yes.
No, Bihar election matter, election commission matter.
Anyhow,
He's requesting if your lordship may have it heard.
We'll come at 2 o'clock.
Your lordship's item.
I have indicated that if he is in a difficulty, we can mention.
We have no other case.
We have no other case. We have adjourned in bad matters only because of this.
It's a humble request.
We'll reassemble at 2 o'clock. We'll reassemble.
Your lordships, the other matters are getting dates.
There'll be some dates to be.
Some dates. Very good.
application before the State Administrative Tribunal. Well, the first time it was considered was 16th of February 2017, when the application was dismissed. Against that note, we filed a writ petition before the High Court. The writ petition came up before a division bench. The division bench looked into the matter, came to a conclusion that because of the rules as they are framed and the notifications issued by the state of West Bengal, there arose a legally enforceable right. But the extent to which that right must be given effect to was a matter which the tribunal should apply its mind. It held in our favor that there was a legally enforceable right, but it needed, therefore, fresh consideration by the tribunal. Well, that judgment is important because many of the submissions which were urged yesterday were in fact urged in that proceeding, and those petitions came to be allowed. That judgment, of the division bench of the Calcutta High Court is of the 31st of August 2018.
Page 368.
That's right, that same judgment. That judgment, was sought to be reviewed by the state. That review also, came to be dismissed.
Page 444.
That's right, Then afterwards, we now come to the application coming back to the tribunal, and the tribunal, has allowed the original application. The various paragraphs which were read, it was suggested that the tribunal had simply overstepped its jurisdiction and had issued some sort of a mandamus, and to borrow the words of Mr. Divan, something alien to the rules was attempted by the tribunal. It was extraneous, to borrow his expression, to the rules and the notifications. Then, the matter naturally goes to the division bench once again. There are two judgments of learned judges. Both these judgments, have found four things, four conclusions. The first conclusion is on the question of Dearness Allowance being claimable as a legally enforceable right has been held by the previous division bench, and the matter has acquired finality. That's the first. The second conclusion is that we read the rules as they are framed clearly suggest that in order to adjust against the cost of inflation, the rule is indeed indicative of the fact that dearness allowance would be payable upon revision from time to time. The concurring judgment, in fact, very elaborately traces this entire AICPI IW for right from the time it evolved in 1944. It's quite useful as a historical account. But then, what is important is that the learned judge comes to the conclusion that on an interpretation of the rule, both on its own terms and as understood by the government in its notification, this was meant to operate as a time-to-time benefit which had to be given because the very purpose of dearness allowance is to protect the real value of money. If one understands this aspect, that dearness allowance is really to protect the true purchasing power which your wages or your salaries are meant to achieve, and keeping in mind the revisions which take place, there is an adjustment, and that is not something which is a matter of bounty, nor is it, a matter of, if I may say so, a claimable right per se. But if, the rules give this as a part of your emoluments, based upon an acceptance of the recommendations of the Pay Commission, then, my lord, I submit, that becomes a compellable obligation. So, my lord, the right to get existing emoluments reckoned in accordance with the rules is a legal right vested in me by the rules and imposes, my lord, what we call in jurisprudence a corresponding obligation or a duty on the state to abide by that rule. And, my lord, that rule, therefore, can legitimately be the subject of a mandamus. Because, my lord, a mandamus always is in the context of a public duty or, my lord, a statutory duty or a constitutional duty. Here it is a case of a statutory duty which is enjoined by the rule. Now, my lord, may I straightaway take your lordships to the first division bench judgment and only 2 or 3 paras to satisfy you that that judgment, my lord, analyzed these defenses. This very same judgment of 1954 Supreme Court, which was cited by Mr. Divan yesterday, that is, my lord, the state of Madhya Pradesh judgment, was also examined, and the court distinguished it on the ground that the words of Fundamental Rule 44, which was being interpreted by Justice Venkatramaya in that judgment, provided for the word may. And because there was the word may, this was a discretion which was vested in the government. So, my lord, this is one aspect. The court also dealt with other judgments and said that the law is, if there is a pay commission, it is not binding on the state government. The state government may accept it, may not accept it, may accept it in part, may accept it in total. Now, my lord, the court, however, says that if it is accepted and is translated into a rule, then that rule imposes an obligation. So then the rule, well, a rule could also permit discretion. Now the question is, my learned friends in their interpretation want to invest this rule with having induced a point A, after which, my lord, there is only a remnant of discretion. And that construction, my lord, is the one which I seek to displace in my submission for your lordship's kind consideration. Because this is, my lord, really the scope of contest. Now, my lord, I will also place those paras of the administrative tribunal. My lord, they were placed, they were rendered, my lord, in a context. The context was that, my lord, the central government was making it a practice to give dearness allowance when necessary, twice a year, because, my lord, twice a year you have the benefit of the discovery of the index. This word average, which your lordships find, is really, my lord, an average of 12 months, which is actually the basis of arriving at that figure 536 in the year 2005. So that is why you have the word average index, because it's over a period, weighted average, my lord, for 12 months. Now, having said that, my lord, let me take you straight away first to the rule and also explain, my lord, that it is time to time, because that is the purpose of the rule. So may I straight away do that, my lord, so that we deal with the heart of the matter.
We want to request.
Please, certainly, my lord.
We are conscious of this fact that we were conscious that you're going to argue that the division bench has already settled the issue and they have not filed any appeal, so therefore a judicature would apply. You are aware of that. Now, we would request you for one thing, because it's going to have pan-India functions. You would please proceed as though we are hearing it for the first time.
Certainly.
Because we have to lay down the.
Certainly, my lord, certainly. There's no difficulty
so that's how we
no difficulty at all.
Mr. Divan,
yes,
Sibyl,
yes,
they were focusing only on the rule.
Yes.
So therefore, how do we read the rule?
Yes.
To your benefit and advantage is what we want you to address.
Certainly, my lord.
First, and then we'll
yes, certainly.
The manner in which.
Certainly. And my lord, even if it is pan-India, I'm not, if I may say so with respect, I'm not overwhelmed by it, because even consistent with all the judgments which I'll place, my lord, it is very clear that the law is that dearness allowance is an integral part of remuneration. Secondly, it is vital because the real value of money must be available to an employee of the government. The third is, if it is left to the determination of a pay commission and the pay commission makes a recommendation, it is open to the respective state government to either accept it or reject it. It is not binding, proprio vigore, although there are judgments which say it is entitled to some weight because it is an expert body, but we will leave it at that. But if it is accepted, then it binds the state government. And if it is, my lord, then metamorphosed into a rule under Article 309, then the rule, my lord, becomes a compelling obligation. So this, my lord, is the. Now, my lord, may I straight away take your lordships to the rules?
Please.
And before that, my lord, if I may invite your lordship's kind attention just to see the context of the rules, which is, my lord, please see Annexure P1, which is at page 97. It is a part of the Pay Commission's report produced by the state. That would be printed page 97, my lord.
Chapter 10.
Yes, chapter 10. And PDF would be 137. This chapter 10, my Lord Justice Mishra has said. In this chapter, we have discussed 4 of the most important allowances now available to the state government employees and also to some of the non-government employees covered by our terms of reference, namely dearness allowance, medical allowance, house rent allowance, and non-practicing allowance. We have not been able to devote our attention to other allowances, including the so-called special allowances that the state government currently pays to its employees, some of its employees. We propose to deal with these allowances in any of the later volumes of our report. Then, my lord, 10.2. Now we first deal with dearness allowance. Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by pay commission gets continuously eroded with the passage of time. Thus arises the need for payment of dearness allowance so as to protect this loss. Now, my lord, this is a rationale for dearness allowance. This is not, my lord, disputed by the state. The state does not say that there is no inflation. The state does not suggest that there is no increase in the cost of living. Now, my lord, please come to 10.3. The state government, since the 1st of April 1979, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of dearness allowance. But almost invariably, there is a time lag in actual payment, and when the same is paid, the same does not include any areas. Right now, only one such installment has remained, due which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from 1st March 2009, was sanctioned by Government of India with effect from 1/1/2008. A major grievance of most of the associations of employees has been non-payment of the DA installments in time, as per Government of India's policy. This is payable twice a year with effect from 1st of January and 1st of July each year. They are also agreed because of non-payment of areas. As per information available, we find that apart from notionally allowing the pending installments at the time of the pay revision in the years 86 and 98, the actual payment of DA during the years 97 to 2008 has been as under. Then, my lord, 10.6. It is evident from the above that state government sanction of the installments does not follow any definite pattern. It is clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the government with effect from 1st July 2008, and then, these are the critical words, my lord, fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all employees within our terms. Now, my lord, before I show you the rules, there is a notification which explains, my lord, how this pay commission came to be constituted, how it has submitted the report, and how has the government viewed it, and how the rules have been framed. May I show that straight away, my lord? Your lordships will find this is annexure. This is, my lord, annexure P3. Well, there are 2 memoranda. One of them is numbered as 1691F, and the second one is 1692F. But let's take, my lord, the first one, which is 1691F. That your lordships will find is at printed page 155. That is, my lord, if I may say so, it's the scanned copy. May I take you, my lord, to the better version, the typed version, which is at printed page 162.
Yes.
Subject clarificatory memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and on allied matters dealt with by the 5th Pay Commission. In Finance Department resolution dated 28 August 2008, the government constituted a pay commission to examine the present structure of pay and conditions of service after taking into account the total package of benefits available to the following categories of employees and to suggest changes which may be desirable and feasible, keeping in view the decisions of the central government on the recommendations of the 6th Central Pay Commission. And now, after this, your lordships will find over the page 163, just above para 2, the Commission submitted its report on the 12th of February 2009. After due consideration of the recommendations of the Commission, the Governor has been pleased to make the decisions set out in the following paragraphs in respect to the employee under category 1A above. Scales of pay. The government has accepted the recommendation of the Commission in respect of running pay bands and grade pay corresponding to its scale of pay without any modification. Now, the next para is important. The revised pay structure, which has been prescribed by the government, is set out in Schedule 1 to the ROPA Rules 2009 relating to services generally published with the notification 1690F. Then, the various rules and regulations. And then these have been, published in the Gazette. Now, here, your lordships will find, please now just scroll over to the most important part, which is at printed page 166. 166.
Clause 10.
Clause 10. And the most critical part, of clause 10 is this. Consequent upon revision of... Sorry.
Yes.
This is 166. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the Dearness Allowance, which a government employee is entitled from time to time since the first day of January 2006, because that is the date of the Central Pay Commission, 1/1/2006, needs to be related to pay in the revised pay structure. Now, your lordships may kindly see the crucial words are the Dearness Allowance to which a government employee is entitled from time to time. Since the 1st of January needs to be related to the pay in the revised structure. This is, my Lord, in response to my Lord Justice Mishra's question, that how do the three clauses work? Because the word is aggregate first. It is 1 plus 2, on which, my Lord, there is 3. Then please see, now this is, my Lord, quite important. And this is how, my Lord, the rule needs to be looked at. Now we come to the rules. Now please see now, my Lord, the rules.
Sorry, 1 minute.
Yes.
The government notification of 23rd of February is the 4th page.
Yes. That is, my Lord, that is the next annexure, my Lord, which is 1692F. I'll place that too at this juncture. And this, my Lord, actually, if I may say so, completely buttresses the position of the respondents. Please see, consequent upon the revision of pay scales of government employees, my Lord, that is printed page would be 168. I think there is also a typed copy which has been provided, which is at printed page 170. 170, it's easier on the eyes. The governor is pleased to decide that the whole time state government employees.
That's something else. That's something.
Oh, sorry.
You have to read from.
Oh, I have to read from that, yes. Yes. And I'm grateful. Well, Lord, please therefore come back to 168. Consequent upon the revision of pay scales of government employees under the provisions of the West Bengal Services Revision of Pay and Allowance Rules 2009, it has become necessary to relate, well, this expression, to relate dearness allowance admissible to a government employee to his basic pay in the revised pay structure in the case he has elected or is deemed to have elected to draw pay in the revised pay structure prescribed under the aforesaid rules. As has been laid down in Rule 12 of the West Bengal Services Revision of Pay and Allowances Rules 2009, that no areas of pay and allowances to which any government employee may be entitled in respect of the period from 1st of January to 2006 to 31st March 2008 shall be paid to the government employee. The dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st of April 2008 only. So, my Lord, while the revised pay structure would be worked out with effect from 1st of January 2006, but you will get no arrears. And from 1st of April 2008, that is, my Lord, that newly revised pay, you will be entitled to dearness allowance. Accordingly, the governor is pleased to decide that the dearness allowance payable to a government employee with effect from 1st of April 2008 shall be at the following rates. And your lordships will find this 2%, 6%, 9%, 12%, 16% are the percentages given by the central government, although it was with effect from 1/1/2006. So, what is important is that time to time. That is reflected in this very notification itself. 1/4/2009 onwards, it says 16% and it leaves it at that. Now, my Lord, let us go to the rule, because this really is the subject of interpretation in our case. Please come to the rules. The rules are, my Lord, they begin annexure P2 at printed page 100. And if your lordship sees,
yes,
in the foreword, which is at printed page 101, it says the West Bengal Services Revision of Pay Allowances Rules 2009. Sorry. That is, my Lord, forward. But it's important to show that page, my Lord, this
better if you read 125.
Yes.
That is the legible one. Yes.
I'm grateful, my Lord.
Yes.
I'm very grateful, my lord. The West Bengal Services Revision of Pay and Allowance Rules 2009 and other notifications on revision of pay of police personnel, civil defense personnel, staff and officers of the Public Service Commission, West Bengal, as well as a memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and allied matters have been published in the extraordinary issue of Kolkata Gazette dated 23rd February 2009. Government has also issued orders sanctioning fresh installments of Dearness Allowance with effect from the 1st of April 2008, my lord, it should be, not 2009. That I think is an error. It's April 2008. So, my lord, now we come to the rules. Let us see the rules.
There is no error because the original one says 2009 only. We really don't know why.
Yes, my lord, but the rule is from 1st of April, as your lordships have seen, 2008. Now, please come to, my lord, printed page 126. Please see 1-2. They shall be deemed to have come into force on the first day of January 2006. That, my lord, coincides with the central government, the 6th pay commission of the central government. Then please now, my lord, come to rule 3. In these rules, unless the context otherwise requires. Now, my lord, nobody has pleaded that there is a context which otherwise requires to depart from these definitions. Please keep that in mind. Now, my lord, the first is existing basic pay. Existing basic pay means the pay drawn in the prescribed existing scale of pay, including stagnation increments, if any, but does not include any other type of pay. And then, my lord, we have that expression existing scale. Then we come to existing emoluments. Existing emoluments mean the aggregate of, which is, my lord, it's the total which has to reach an employee. But it has different elements. The first is existing basic pay, that is, my lord, the unrevised pay, dearness pay appropriate to the basic pay, and dearness allowance appropriate to the basic pay plus dearness pay at index average 536, 1982 is equal to 100. Now, my lord, the use of this word index, my lord, index itself, my lord, it's a Latin expression, it means a pointer. This index is really the pointer. And how do you calculate the dearness allowance? It is with reference to this numerical 536. 1982 is equal to 100. That is, my lord, 100 rupees of 1982 today is unique 536 to draw the value of 100 rupees which you had in 1982. Now, my lord, your lordships will notice, and that there is actually, my lord, a calculation which I made. It is clear, my lord, from all the rates declared by the central government, they have used this formula. And this formula is the other side as well. This formula, my lord, shows that the denominator is always 536. So that figure 536, which your lordship saw, is critical. Please have a look at this. Please see, my lord, please see for a moment column H. We are now talking of April 2008. In April 2008, my lord, the DA given by the central government was 12%. Does your lordship find that in column C?
Yeah.
I'm sorry.
Yes.
It was 12% in April 2008. My lord, we got 2%. Then, my lord, the balance was 10%. Now, my lord, what is the formula for calculation of central government DA rate as reflected in column C? It is 605. That is, my lord, 536 had gone up to 605.
Yes, yes.
This 536, my lord, the AI CPI index rose to 605. So, my lord, you divide it by 536 and you also deduct that 100 because 1982 is equal to 100 has already been subsumed. That is how you get, my lord, 12.87. But, my lord, they now forget the decimals. They give it closer to, that is how, my lord, it is done. So each of these, your lordships will find, January 2009, 22%, and my lord, we got 9%, but the calculation in H is 656. Sorry.
No, sorry.
656 upon 536, keeping in view 100, that comes to 22.39. So that figure, that average index, which says 536 within brackets 1982 is equal to 100, is the factor of calculation at each point of time when the index changes. Now, please see the next one, 727 divided by 536, and again offsetting 100, you get the percentage, 35%. 815, again, my lord, you get 52%. Then 887, you get 65%. So, my lord, there is actually a scientific, it is almost like an actuarial calculation. Please then turn over the page. In January 2013, the figure, my lord, becomes 969. That takes you up to 80.78%. Then, my lord, in January 2014, it increases up to 1075. So 100.56%. Then January of 2015, it goes up to 1143. That is how it comes to 113%. In January of 2016, it goes to 1210. And so on, my lord. Your lordships will find the calculations are available right for all the revisions done by the central government using the AI CPI index. So, my lord, this average is done only by the central government. Now, if you look at the structure of the rule with me now, the words are important. Dearness allowance, the crucial word, my lord, here is appropriate. That word appropriate means it must be appropriate to the basic pay plus dearness pay at index average 536. So, my lord, this index average 536, if 536, my lord, undergoes a change, then taking into account 536 as a denominator, you work out the percentage of increase. This, my lord, is really the purpose of this particular rule. So, my lord, instead of even taking a position that this is an implicit arrangement in the rule, my submission, my lord, is that this is explicit because it is A, an aggregate, B, it is appropriate to the revised pay, C, at index average. And that index average, my lord, once you say index, it means, my lord, that that average will move according to a change in 536. And that is why, my lord, that para 10, which I showed to your lordship, said time to time. So this, my lord, is really the reading of the judgment of the division bench of the High Court. But, my lord, there was one other question which arose before the division bench. They were employees, my lord, of the government of West Bengal who were governed by the ROPA rules. But fortuitously, some of them, my lord, were working at the Bonga Bhavan in Delhi. Some of them were in a youth hostel in Chennai. And, my lord, they were being granted actually the dearness allowance exactly on the basis of the central government rates. Now, that was an additional factor for the court to say that this is a case of discrimination because they're governed by the same rules. And there is no difference, there is no intelligible difference here that they should get a higher. But it was taken into account. But it was not the primary reason for applying. The primary reason is that in the very nature of a dearness allowance, if it is meant to offset, my lord, cost of living increase. The increase, my lord, in essential commodities. My lord, it is done also in a very scientific way by the Bureau of the Labour Ministry. They, my lord, actually get data from the Ministry of Consumer Affairs every month on every item. And, my lord, why they apply industrial workers is they take, my lord, much lesser in terms of, that is, essentials, basic essentials which are required. But if their prices have gone up, then, my lord, they take data from all over India and make an adjustment. And this adjustment, my lord, like even today, as we speak of yesterday, my lord, the central government for the festive season, but because the AI CPI index went up, gave, my lord, a 3% increase to the employees. Now, what I'm saying, my lord, is that this is on the basis of understanding that dearness allowance is not a matter of race. Dearness allowance is integral for the real value of a wage. So, my lord, if the real value of a wage has to be protected, of course, my lord, if the state of West Bengal, let us say, had a Mahalanobis formula, a different formula to actually calculate dearness allowance, it's very different. My Lord Justice Mishra asked an extremely critical question yesterday. What was the basis on which you changed? What was the working? The working, my lord, for a good part of time was only the central government's, but it was, my lord, postponed, as your lordships have seen. So, my lord, the issue is, if the rule gives this method of calculation, is it not binding on a state government in terms of the emoluments which have to be available to a government servant? In addition to this, my lord,
can you provide us an exemplar of an employee working at Bang Bhavan in Delhi or at Chennai being paid DA in terms of the central government rate?
Yes, my lord, I have
an exemplar.
Yes,
of any employee.
Yes, my lord. Yes.
Who is working at Bang Bhavan vis-a-vis the same cadre of employee getting a less amount of DA if he is working in Calcutta.
Exactly. Lord, I'm showing you the chart. I'm deeply grateful. Please come, my lord, to a chart. Yes. Please see, my lord, Annexure CA2, which your lordships will find is at PDF page 895, but it might be printed page 17. It's a part of the counter affidavit of the second respondent. It is an annexure, my lord, CA2. And this has not been disputed. C1.
It's a counter affidavit.
Yes. Of respondent 2, my lord.
It's mine, my lord, and it's not been disputed.
Yes. This chart is extremely useful. I'm taking advantage of the material available for us.
Counter of respondent number 2.
Yes, my lord.
Page?
Printed page, my lord, this would be 17. Printed page 17. Annexure C1.
Yes, please.
Now, your lordships will notice that at page 17 is the chart. Chart showing the discrimination of payment of dearness allowance between the state government employees working at Banga Bhavan, New Delhi, and Youth Hostel, Chennai, and West Bengal state government employees working in the state of West Bengal in connection with ROPA 2009 and 2019. Now, my lord, your lordship sees April 2008 is from when, my lord, we were entitled to a pay. 1st April 2008. We got 2%. Is your lordship able to see that chart? We got 2%. Your lordships recollect that in that notification. My lord, Bongo Bhavan, they applied the central government dearness allowance and gave 12. Similarly, my lord, all the payments which your lordships will see in column number 3 are exactly those of the central government AICPL. Well, this is not even one exemplar. This is continuing from 2008. All the way your lordships will find what was it which we got in the last but one column, and what is it, my lord, others who were also governed by the same statutory rules, what did they get? So, my lord, the suggestion by the state that they don't know how to calculate this is certainly not, my lord, because they are the ones who gave this. Please see 27, 35, they followed strictly, my lord, all the way, as your lordships will find, right up to, all the way, my lord, I'm now going to take you right up to 2019, December 2019. They got exactly what was available in terms of the calculation of that formula for the central government. So this is the point, my lord. And this is not merely a case of incidental discrimination. This is a case where the same employer, for some of its employees, is making available dearness allowance exactly, my lord, ditto of the central government based on this formula. So, my lord, the point which is being made by Mr. Devar, that it was static, it became fossilized on the day, my lord, as I said, in any case, the pleadings, my lord, are in fact inconsistent with this. If your lordship see the judgment of Justice Samalto and Justice Tandon, the two learned judges, nowhere, my lord, is there a suggestion that it stood frozen at a point of time, because, my lord, dearness allowance in its very concept is a variable allowance. This is the point.
Is there any separate GO issued by the government of West Bengal in respect of the Bangabhavan employees and Juni employees?
No.
I think there is, my lord, judges.
Has been subject to correction. Page. Annexure. Annexure 31, my lord, I'm given to understand, of the page 31. Please go to page
of the same one.
31 of the counter.
Same counter of R2.
Of R2, my lord.
Page?
It's page 31, my lord. Annexure C2. My lord, this is actually with reference to the ROPA rules of 2019. This is the second set.
But it continues the same problem.
My lord, I want to make one thing clear. These cases are governed, my lord, with reference to the ROPA rules of 2008-9. 2009 rules, my lord, are the issue in this case. But even after the ROPA rules of 2019 came, it's important to see, my lord, this very significant point.
No, this happened for the first time in 2019.
But that is because the 2019 rules, my lord, did away with dearness allowance in the rule. So what they did was, they issued this order consequent upon the revision of pay and allowances of state government employees with effect from 1st of January 2020. Under ROPA rules 2019, Governor has been pleased to order that the state government employees posted in New Delhi will draw dearness allowance, house rent allowance, so and so, with effect from dearness allowance at the central government rate. So, my lord, although the new rules abolished dearness allowance, but they followed that same pattern of giving the central government DA in respect of these employees. And, my lord, the 2019 rules are not the subject here today because, my lord, still discussions are going on. The Pay Commission, which dealt with the 2019 rules, my lord, the report was published only 2 months ago. So that is being examined, how to deal with that. Because, my lord, that actually did away with dearness allowance. So notwithstanding dearness allowance disappearing from the 2019 rules, they continued to give, my lord, the central government DA.
Presently, they are not getting DA.
Where, my lord, They were no, now, my lord, now after a period, that is the new rules of 2019, my lord, they were notified in September 2019 with effect from 1/1/2020. With effect from 1/1/2020 for a period of almost 2.5 years, we didn't get any DA. Then, my lord, there has been small driblets of a minuscule percentage which has been given to us as a dearness allowance, which is why, my lord, it is important to state the point that, my lord, this is not gratis. This idea that dearness allowance is something which is gratuitous.
The methodology is the same.
Exactly.
2006 to 2008.
Yes.
Nothing was paid.
Exactly.
Again, 2019 to 21.
I'm grateful.
Nothing was paid.
Exactly. Well, this is the point.
They are saving it.
Yes.
Like old days moneylenders.
I couldn't.
Businessmen.
Yes.
Use the money given to others.
Yes.
For their own business.
Well, for 2 years, not to pay you from 1st of April 2008 and give you in driblets. That is, my lord, what was given in 1st of January 2006, you're making available to me in 2008. So, my lord, this is the real case.
Perhaps you can, let us know.
Yes.
The counter affidavit filed by
respondent 2.
Page 16 and page 31. These are documents of the year 2022.
Yes.
And 2020. Is there any document available there on record, or perhaps you can place?
May I just search the record and give you a yes?
We are interested to know between the period 2009 and 2009.
Yes, 2009 up to 19.
That would be. You may not answer immediately.
I'll just yes, certainly.
My lords, we do actually have that.
That is reflection. We know that, but we just want to Yes, please. May please.
I understand Mr. Sibal was in some difficulty. I think it made a.
But we said we'll assemble at 2 and then whatever is to be done, tell us.
Yes, I leave it to your lordship. Otherwise, my lords, I'll.
No. We are not saying that we will not adjourn for Mr. Sibal. Should Mr. Sibal,
Thursday?
when do you
Thursday.
will accommodate Mr. Sibal? There's no difference.
I leave it to your lordship. But otherwise, I'll carry it on.
No, you're always welcome, sir.
Yeah. But Mr. Sibal is on his legs. That's why.
You're always welcome. Then after Mr. Sibal finishes, concludes your wish to add, there's no difficulty. We will definitely accommodate Mr. Sibal. There's no doubt. There's no doubt in our mind. My lord, the thing is, 1 minute, ma'am. Just 1 minute. One difficulty which we are seeing with another senior counsel is this, that twice we have, 2-3 times we have accommodated him. And we understand he is very, very in demand in other courts. Today also we had to adjourn. But the only thing is that next date he should be there. That's about all.
Lordship may have it on Thursday or next Wednesday.
Not Thursday.
So miscellaneous.
Wednesday.
Thursday is a miscellaneous day.
Next Wednesday.
My lords.
What is that you wish to say? Okay.
My lords, could we just have one small request, which is that they have 3 eminent counsel. It's at the stage of rejoinder. Of course, Mr. Sibal must be accommodated, and he's in if he's on his legs. But my lords, perhaps my lords may consider that given that there have been 11 adjournments.
May I just only say one thing?
Yes.
On the last day, Mr. Patwalia got up to say some date. And I responded to Mr. Patwalia by saying that we are not a vending machine. You insert a coin and judgment will come in. When I went back, let me share this with you. And Mr. Patwalia is here. I must apologize to him.
No, not at all.
No, 1 minute.
These things happen in court all the time.
1 minute. When I went home, let me tell you, all my law clubs and interns are sitting here. And they told me that perhaps, sir, you were unduly harsh to Mr. Patwalia.
They do not know, my lord, for how long.
1 minute. You know me.
You should have told them, my lord, that when your lordship was in Shimla and Chandigarh, since then.
You know me, I admit my mistake, I apologize.
No, there is nothing. I have forgotten about it. No, don't remember.
Ma'am, only thing is, what is the tearing urgency?
I understand.
That's it. Simple. After all, they are asking for 1 week only. We know that there are 3 counsels. We also know that Mr. Devan is finished. We have been accommodating each one of you day in and day out. There's no difference.
Absolutely, my lords. There's no doubt about that.
Please.
Wednesday.
Wednesday का board Wednesday, no.
Wednesday is tomorrow.
Next Wednesday.
Obviously not.
Ugly, but not 20th. 20th already. See, there is 1% chance of this 20th may not be convenient for me personally. 1% chance, but I'm not sure. If I'm, then we'll move on the premise that we'll keep it for 20th. But if I'm not there, then you'll have to accommodate me.
Goes without saying.
All right.
And then it'll go to next 8 months. Yes. नहीं फिर 26 को पढ़ेंगे 26
Yes,
26
26 Tuesday. That's good. 26.
Yeah.
Then your lordship may keep it only for 26th, then to begin with only, then why do that?
Or would 25th also suit? I think 25th.
25th is also all right, end of the board.
Monday,
end of the board we can do. Yes.
Monday, which way? 20th.
25th Monday.
Twenty-sixth better. 26th.
What we'll do is then, Mr. Patwalia,
26th is okay, Manoj.
26th we'll keep it in the morning.
So grateful.
Or keep it in the morning.
Yes.
All right.
Please inform Mr. Sipal. 26th morning, we'll keep it top of the board.
All great.
List on 26th, top of the board.
My lords, may I? My lords, may I? My lords, some very new arguments have been made that are not before the courts below. So we will just take a very brief time to address my lords after they are done.
No problem.
So great.
We have told you that
so great.
Till the time everyone says thank you very much, we will not.
We are so grateful.
So 26th, immediately after the fresh matters, hail and other matters, TP matters, we'll take it up.
As your lordship.
Thank you.
আপনার ইন্টারেস্ট তো বাড়তেই থাকছে, কিন্তু ব্যাংক এখন এটাকে অকশনে বিক্রি করবে। কোন ডিপার্টমেন্ট কি বললো সেটা কোর্টের জানা নেই। এখানে উকিলবাবু আছে, উকিলবাবু বলছেন যে 29 লাখ টাকা ডিউ আছে। যে উকিলবাবু বলেছে সে উকিলবাবু আপনাকে ঠিক বলেননি। যিনি বলেছেন উনি অর্ধেক কথা বলেছেন আর অর্ধেক কথা বলেননি। এই রিট পিটিশনটা কে তৈরি করে দিয়েছে আপনাকে?
ওই ব্যারাকপুরের বাবুর,
ব্যারাকপুরের উকিলবাবু?
ব্যারাকপুরের একজন উকিল বাবু।
তো উনি এখানে এলেন না কেন? আপনি পিটিশনার? বলুন।
ম্যাডাম, আমার ব্যাংক ডিএম সাহেবের একটা অর্ডার হয়েছে, সেই অর্ডারে আমি টাকা নিয়ে ঘুরছি, কিন্তু ব্যাংক সেটা নিচ্ছে না।
কোথায় অর্ডার হয়েছে?
22 নম্বর পেজে।
আপনি কি বাড়ির মালিক?
ফ্ল্যাটের মালিক।
কত টাকা লোন নিয়েছিলেন?
14 লাখ টাকা।
Where are the figures appearing? Will you please show me?
Yes, but the figures, if your lordship sees the possession notice at page 21. This is also there in the 32 notice, which is page 14. There, my lord, the loan, the amount of the loan was 13,52,000.
13,52, paragraph 3, page 15.
Page 15, if your lordship sees, paragraph 3. Total outstanding.
Page 21 you showed me.
Yes, that's the possession.
Notice.
Yes.
1352.
1352 as on 8th May 2019.
Right.
Yes, my lord. Now, my lord, what has happened? The
description is one self-style, tile floored flat, 4th floor, super built area 942 square feet.
Yes.
Petitioner is the owner.
Petitioner is the owner.
You've taken symbolic possession?
Well, no, but the police, the payments have been made to the police, and the symbolic possession is required to be taken.
How much have you received?
No, actual possession. Actual physical possession has not been taken pursuant to the district magistrate's order. But when a symbolic possession, as regards when the possession notice has been given, symbolic possession has been taken. But when after the section 14 order was passed, we have to incur certain expenses for the police. But that we have paid. Now it is in process. But in the writ petition, what the petitioner is saying that
Did the petitioner approach DRT?
yes, that is the point of maintainability.
Did he approach?
No.
He didn't.
No appeal from this order.
Right. Now, is he paying something to y'all?
What he has offered, that offer has already been rejected.
Yes.
What he has offered was, that's at page 24. He is offering the amount which was due. That was the total outstanding back in 2019. But now, 5 years have gone by, interest has accrued, but we have rejected his offer, which is at page 29.
1352 he is offering now?
Yes. That's the amount which was outstanding when we issued the notice under 13.2.
I understand. 1352 is offering
Yes,
now.
that he is offering. 5 years have gone by. We have
Yes.
rejected his.
What will you do? You'll auction the property, isn't
Yes,
it?
we will auction the property.
And,
after taking possession, we will auction the property.
Right. Now, if he puts in the money to you and he is willing to pay the interest, then would you still?
As on this date, the due is 29,56,000. He's offering less than a half of it. Without going into the question of maintainability, since he is appearing
Residential flat, he.
yes, that is why.
Otherwise, the court would not have entertained at all.
I appreciate. But what I can do, if the petitioner pays off this amount,
29.
that is the outstanding.
All right. ব্যাংকের বক্তব্য হচ্ছে 29 লক্ষ টাকার কাছাকাছি ডিউ আছে, আপনি 13,52,000 কিছু এরকম দেওয়ার বলছেন।
হুজুর, ডিএম সাহেবের অর্ডার করেছেন 10 জুলাই, আমি অর্ডারটা হাতে পেয়েছি 3 সেপ্টেম্বর, প্রায় 56 দিন বাদে।
এই অর্ডারটা 6 মাস সময় আছে এক্সিকিউট করার জন্য।
আমি এই অর্ডারের টাকাটা পুরোটাই জোগাড় করেছি, 5 লক্ষ টাকা ডাব নিয়ে ঘুরছি, পাঠিয়েছিলাম ব্যাংকে চিঠি।
5 লক্ষ?
5 লক্ষ টাকা 3টে কিস্তিতে বলেছিলাম।
আচ্ছা।
অক্টোবর, নভেম্বর, ডিসেম্বর 5 লক্ষ টাকা ওরা বলেছিল দিতে, আমি সঙ্গে সঙ্গে পাঠিয়ে দিয়েছি। 26 নয় হুজুর, আপনি এটা দেখুন, আমার এই 26 নম্বর পেজে
5 লক্ষ টাকা করে 3টে ড্রাফট।
না, 5 লক্ষ, 4 লক্ষ, 4 লক্ষ,
মানে সব শুধু 13,52,000। কিন্তু এই টাকাটা তো বাকি ছিল 2019 সালে, এখন 24 সাল চলছে, তাহলে ইন্টারেস্ট কিছু বেড়ে গেছে।
কিন্তু হুজুর 24 সালে 10ই জুলাই এই অর্ডারটা কিন্তু হয়েছে।
আপনি দেখুন 10ই জুলাই যে অর্ডারটা করেছে তাতে লেখা আছে 13 লাখ টাকা ডিউ ছিল 19 সালে, বলেনি কিন্তু 24 সালে 13 লাখ টাকা ডিউ আছে। বুঝতে পেরেছেন? এটা বলছে 19 সাল পর্যন্ত এটা বাকি ছিল।
তাহলে
আপনার ইন্টারেস্ট তো বাড়তেই থাকছে,
কিন্তু
ব্যাংক এখন এটাকে অকশনে বিক্রি করবে। এবার আপনি কি করবেন? আপনার নিয়ম অনুযায়ী আপনাকে ডিআরটি দিতে হবে।
ডিপার্টমেন্ট থেকে বলছে কখনো 16 লাখ টাকা, লাস্টে নেমেছে 14 লাখ টাকা।
কোন ডিপার্টমেন্ট কি বললো সেটা কোর্টের জানা নেই। এখানে উকিলবাবু আছে, উকিলবাবু বলছেন যে 29 লাখ টাকা ডিউ আছে।
29 লক্ষ টাকা বুঝিয়ে দেওয়ার,
সেটা আমার পক্ষে এখানে বিচার করা সম্ভব না। এটা ব্যাংকের টাকা, ব্যাংক বিচার করবেন যে কত নেবে না নেবে।
যে সাহেবের রিপোর্টে তো যে টাকাটা, সেই অ্যামাউন্ট আমি দিতে পুরোপুরি রাজি আছি।
কোথায় আছে বলুন তো? ডিএম সাহেবের রিপোর্টে পড়ুন তো কোথায় আছে। এই 13 লাখ টাকা যেটা বলছেন সেটা কোথায় আছে দেখান। বলুন কোথায় আছে, আপনি পড়েছেন? কে বলেছে আপনাকে ডিএম সাহেবের এই টাকাটা বলা আছে? কেউ বলেছে তো আপনাকে?
হ্যাঁ।
কে বলেছে?
আমাকে যে উকিলবাবু একটু করছেন তিনি বলেছেন।
যে উকিলবাবু বলেছে, সে উকিলবাবু আপনাকে ঠিক বলেননি। যিনি বলেছেন উনি অর্ধেক কথা বলেছেন আর অর্ধেক কথা বলেননি। টাকাটা বলেছে ঠিকই, কিন্তু সেটা ডিউ ছিল 19 সাল পর্যন্ত। বুঝতে পেরেছেন? এবার আপনি কি করবেন সেটা আপনি, আমি জানি না কি করবেন। ব্যাংকের টাকা
অর্ডারটা স্যার
24 সালে কেন হলো সেটা আপনি ডিআরটি তে যান, আমি আপনাকে ডিআরটি তে পাঠিয়ে দিচ্ছি, আপনি সেখানে চলে যান। ঠিক আছে? তাতে কিন্তু আপনি, ব্যাংক কিন্তু থেমে থাকবে না, ব্যাংক কিন্তু তার কাজ করে যাবে। কি বুঝছেন? How much can you?
But I'll have to take instruction.
Yes.
But
আর কটা বাড়ি আছে আপনার?
আর কোথাও নেই।
কোথাও বাড়ি নেই?
But as it appears, the secured there are two secured properties. If your lordship sees the 13-2 notice, page 17 is the schedule to the 13-2 notice. Page 17, what is one is a land and another one is a self-contained flat, which perhaps the petitioner resides in. There are two properties, and the section 14 order has been passed. In
1 minute. One that piece and parcel of land is 5 cutters, 33 chitaks, more or less, along with a G+4 story building. Possibly, this flat is in this property.
Yes, perhaps, but even
But then he does apart from this flat, he doesn't have anything. It does not mean that the entire G+4 story building is mortgaged to you.
That is what is recorded in the schedule of property, even in the DM's order. Your lordship sees page 22, schedule of the property. Lordship will kindly have a note. Page 22, lordship has
22.
Page 22 is the section 14 order. Your lordship has the schedule of property, serial number 1, where the property is described.
All I can see it is described, but whether it is the same premises number 21, name and identified as Milon.
Aguyati first line address appears to be the same.
Yes, it's the same address.
Address appears to be the same, but perhaps it may also be the land as well as the flat. I'll have to take clarification on that.
When it's a flat, you have the corresponding land also there, but it does not mean that the 5 cutters, 36 chitaks.
I don't think so. I don't.
No, it is not. It's this only 924, 42 square feet.
Yes.
Super built.
Yes. Yes, that's
then.
It. But I'm not saying anything on that. But if the petitioner can at least offer a reasonable amount, I can take instruction. If less than a half, I cannot even ask.
No, he goes till 1352. He has been able to.
He wants to. He wants to pay.
He has been able to obtain drafts also for this amount.
He has offered us 5 lakh. But he's saying that he's willing to, or he can pay us 1352. That is less than half.
Would you give him a hearing and come up with some positive instruction?
You can do that, my lord. Lordship, instead of that, kindly keeps it tomorrow. I'll take instruction from the bank, and my lord, we'll come back tomorrow. Whether we can have a hearing held and he can again offer something, then we can.
Then day after tomorrow.
Very well, my lord. Day after tomorrow.
Please come.
Keeps the point of maintainability open.
Feeling low on game credits? Time Zone's got your back. From 15th to 17th August, it's the $double offer. Play 2 times of what you pay. More games, more tickets, more bragging rights. So grab your power card, call your squad, and head to Time Zone for double the fun and 0 excuses. Visit your nearest Time Zone now. Conditions apply.
The residential flat of the petitioner having super built area of 942 square feet.
Lord, may I have a lordship's leave? Wait, my colleague is here.
Have been directed to be taken physical possession as the petitioner failed to pay off the dues of the loan which was taken. Stop. A sum of rupees 13,52,238,66 was due and payable by the petitioner on 8th May 2019, when the notice under section 13 within bracket 2 of the Surfacy Act 2002 was issued. Stop. The District Magistrate, North 24 Parganas has passed order on 10th July 2024, allegedly received by the petitioner in September 2024. Intimating that physical possession of the property would be taken. Stop. Paragraph. The petitioner has rushed to this court by mentioning that he is